Hello everyone. In today's video, we are going to cover our sales of goods act unit number 2, that is conditions and warranty. So I hope you have already covered lesson number 1, unit number 1 of the sales of goods act, because if you will understand unit number 1, then only you can continue with the unit number 2, because it is in continuation. So if you have not watched unit 1, first go and watch unit 1 and then you come here to watch unit number 2, condition and warranty. So guys, this unit is comparatively smaller than unit 1 and easier than unit 1. In this unit only two topics are discussed. One is your condition and another is your warranty. So first we will understand some basic. So how many sections are there, guys? Section 11 is there, stipulation as to time. Section 12 is there, condition and warranty. And then section 13 is there, when condition will be treated as warranty. Okay, so after that, there are some implied conditions which are given in 14, 15, 16 and 17. And there are some implied warranty given, that's it. And there is a concept of caveat emptor, that's it. And that's the end of the lesson. Only this many topics are there. So basically, if you will see, majorly there is three concepts: conditions, warranties and caveat emptor. Three topics are there, three concepts are there in this particular unit, and the whole unit is summarized in the summary notes. So first reading, don't worry, when we will study in the class, so in the class while studying we will refer the material also, and we will refer the short notes also. However, when you will do the second and third revision, you can go through the short notes, because everything is covered in the short notes fully. So your whole chapter is covered here, and these notes are prepared from the lesson only, so you can cover from here. So let's get started. First, let's start with section number 11. So section number 11 says that whenever we enter into contract of sale, so we give some time for payment and we give some time for delivery. Let's say when you ordered something from Amazon, they give you a date of expected delivery, ki your goods will be delivered by that date. So ma'am, is it essence of the contract? Essence means, is it essential? Otherwise the other person can cancel the contract. So when we talk about the time of the delivery and the time of the payment, the question is whether it is essence or not. So it is given in section 11. Section 11 says that when in a contract, stipulation is given with respect to payment. Stipulation means a condition, or I have told that I will make the payment by, let's say, 25th October. So any time for payment is given. What if the payment is not done within that time? Can you cancel the contract? The answer is no. Payment, one few days it can be upper niche here and there. If you don't make payment on time, the other person cannot cancel the contract. So we can say that time of payment is not the essence of contract. Not the essence means it's not that essential. Essence means essential. It's not essential ki if you don't make payment on time, the other person cannot cannot cancel the contract. But when we talk about time for delivery of goods, that is essence of contract, because if you won't make delivery on time, then the other person can repudiate or cancel the contract. So the question is whether time for payment is essence? No. But the time for delivery is essence? Yes. It might be possible. And let's say today is my birthday. Today is my birthday. I ordered cake from Funs and Petals, and they said that ki haan, 2 hours mein we will make delivery. They did not make delivery today. They are making delivery tomorrow. Is it any useful? My birthday is today na, so I ordered cake today, you deliver me cake today. If you will deliver cake tomorrow, is it of any use to me? No. Can I say that no, I don't want my delivery, give my refund? Yes, I can say that, because here delivery is essence. So delivery of goods ka time is essential, and if you won't deliver on time, then the other person can cancel the contract or avoid the contract. So this is very for the section and number 11. Very quickly come to your unit number 2. Now here, if you will see page number, first page only, section number 11, stipulation as to time is given. When we talk about time, so time for payment is not essential, but time for delivery is essential. So here one point is given: as regard to the time for payment of the price, unless a different intention appears, stipulation as regard this. Stipulation as regard this means payment. Stipulation regarding the time of the payment, it is not deemed to be essence of the contract. Not deemed to be essence matlab, if you don't make payment on time, they cannot cancel the contract. So it is not the essence of the contract. But time for delivery of the goods must be made without any delay, whether or not such a stipulation is of the essence of the contract depends on the term agreement. So whether or not it is essence of contract or not depend upon the terms and agreements of the contract, but delivery should be made on time. So delivery is the essence of the contract. So is there two summary we can derive ki time for payment is not the essence, but time for delivery is the essence of the contract. Okay, so here you can say stipulation as to time of the payment is not the essence of the contract, but delivery of the goods must be made without any delay, and whether it is essence or not depend upon the terms and conditions. So usually it is delivery is the essence of the contract, but price of goods may be fixed by the contract or may be agreed to be fixed later on in a specific manner. Stipulation as to time of delivery are usually, see here one point is given कि time for delivery of the contract is usually the essence of the contract. Here Bakwas point is given repeated, we already know price may be fixed in the contract or price may be fixed later on also. So here you can write stipulation as to here you can write one thing, time of, you can add time of delivery, this thing you can add here. Okay, so stipulation as to time of delivery of goods is the essence of the contract. Not very important, a small section. Okay, now we are going to start the real chapter, that is conditions and warranties. Conditions and warranties, very quickly come here. Now, what do you mean by condition and warranty? See, warranty, though you must have heard everywhere. Ki usually, let's say I purchased this phone, so it came with a 1 year warranty. 1 year warranty means if 1 year में any manufacturing defect will be there, any problem will be there in the phone, then Apple will replace this phone for me, or they will repair this phone for me. So that is warranty. Warranty, you have already heard ki whenever you purchase any goods, you get a warranty. Especially electronic device mein you get warranty, 1 year warranty, 3 year warranty, 5 year warranty. So warranty to you have already heard. Goods mein whenever you sale and purchase goods, there is a warranty. But what do you mean by condition? Conditions means essential condition which have to be fulfilled. So these two terms we will understand in very detail, condition and warranty. Now this is given in section 12. Let's understand it. Let's say this is the seller. Okay, this person is the seller, and let's say they are selling some whatever things. Here she is selling fruits. Now whenever you are selling any goods, now you make a lot of statements and representations. For example, I am selling this bottle. Sorry, for example, I am selling this bottle. So I am the seller, I'm selling this bottle. So I will make a lot of representation while selling this. I will say, oh, this bottle carries 100 sorry 1 liter of water. 1 liter water you can carry in this bottle. In this bottle now there is this lead wala option from where you can just push, sorry, you can push it to close it, and you can just push it to open it, and from this you can sip water from here also. There is a customization of name also available here. So I'm just giving a lot of representation ki this bottle is made of stainless steel, and this bottle is made of insulator, whatever, it can keep hot and cold water for 24 hours. So I'm making a lot of statements. Is it important that those statements should be true? What if I'm just feka fucking? Feka fucking means, this is my slang language. Feka fucking means, what if I'm lying? What if I'm just lying just to sell this product? What if this bottle is cannot keep hot and cold water, like hot for 24 hours and cannot keep cold water for 24 hours? What if I'm lying? Then what will happen? So a seller, while selling any product, now makes a lot of representation and statement. So some statements are, we already know some statements does not form a part of the contract, which are just your opinion and which does not have any legal effect. For example, I am selling you clothes. So for example, I'm selling you dress. So you are purchasing a birthday dress for yourself, and I'm the seller. I'm selling you birthday dress. So let's say one dress you tried, and I'm just saying, oh my god, you are just looking like a Katrina Kaif in this dress. You look like just आसमान से कोकिल कंठी अप्सरा लग रही हो. So I'm just praising you. I'm saying ki, oh wow, beautiful, just looking like a wow, you are looking so beautiful in this dress. And you got so overwhelmed, so you purchased that dress. Later on, when you went to the market or the party after wearing this dress, everyone was like, oh, what are you wearing, it's looking so bad and all. So now you came to return that dress to me. Will I take the return? The answer is no. Why? Because I am saying ki, oh, this dress is looking beautiful, you are looking like a Katrina Kaif. This does not have any legal effect because this is just my opinion. It is my opinion na ki you are looking like a Katrina Kaif, looking like a wow. So it is not a part of the contract. So a seller, while selling any product or goods makes a lot of statements. Some statements are just his opinion. For example, I'm selling clothes, I'm selling dresses, so I'm just making my opinion ki, oh, you are looking, this dress looks beautiful on you, perfect, you should wear this. So this is just my opinion. So even if I'm lying, even if you look pathetic in that dress and I'm lying, then also it will not have any legal effect. It will have no legal effect because this is just my opinion. So it does not form part of the contract. But certain statements form part of the contract, and they are known as stipulation. They are known as stipulation. For example, if I am making a claim that this bottle carries 1 liter of water, then this is stipulation because this is essential. It will have legal effect. Now let's say if this bottle capacity is only 500 ml, or let's say 800 ml, not 1 liter, then buyer can return this bottle to me. Madam, you said ki this bottle carries 1 liter water, but this bottle carries only 800 ml of water. So now you can return this bottle to me because this is an important statement that I'm making to you. So this is known as stipulation and it will have legal effect. So this will form a part of contract. So please understand, a seller, whenever selling any goods, makes a lot of statements. Some statements are merely his opinion, so they do not form part of the contract and they do not have any legal effect. You cannot take action against me, neither you can return back the goods, nor you can claim any damages. Even if you look pathetic in that dress wala example mein, you cannot claim any damages or compensation from me because those were just my opinion. However, some statements made by the seller form part of the contract. That means they have legal effect and stipulation. For example, if I am selling you 1 kg rice, I'm telling you ki in this packet there is 1 kg rice, then it is an important stipulation. There should be 1 kg rice. If let's say you found out ki it has only 800 grams of rice, you can file a case against me. You can return the rice to me, or you can claim compensation because this will have a legal effect. So to summarize, all the statements and representations made by the seller, some are just opinion which does not form part of the contract, so they have no legal effect. However, some statements form part of the contract, they have legal effect and they are known as stipulation. This much understood? Yes, ma'am. Now, stipulation are of two type. Some stipulation are very important for a buyer, and some stipulation are less important or less significant. Some stipulation are very important. They are essential. They are the main purpose of the contract. They are essential for the main purpose of the contract, and they are known as conditions. However, some stipulation are less important. You can say they are secondary or they are collateral to the main purpose. They are not the main purpose. These are the main purpose condition. But warranties are not the main purpose. They are collateral to the main purpose and they are known as warranty. Okay, so that is the name of your lesson, conditions and warranty. So now we will understand condition and warranty in very detail. Let's take an example. I went to a shop. I said, Bhaiya, give me India Gate Basmati rice. Okay. I said I want only and only India Gate Basmati rice. India Gate Basmati rice is a brand. It's a brand. Uske rice. Some people, love that rice, India Gate Basmati rice, and they don't like eating any other rice. They like eating only India Gate Basmati rice. So let's say I went to a grocery store and I said ki I want only India Gate Basmati rice. So he said okay. He gave one rice packet to me. I took it and I gave him price and I took it home. Now please understand, after coming home, I just saw ki oh, India Gate Basmati rice ka bas outside wrapper is there. After I removed it, I saw ki oh my god, after I prepared it, I ate it, I saw oh my god, this is not India Gate Basmati rice, this is any other rice, I don't like it. So please understand, for me, कि I want only India Gate Basmati rice. That was very essential for me. कि now seller said कि हाँ madam, this rice is India Gate Basmati rice. So seller sold rice to me by saying that this is India Gate Basmati rice. This is the stipulation made by the seller. Seller said that it is India Gate Basmati rice. Is it important? Yes, for me, I want only India Gate Basmati rice. I eat only India Gate Basmati rice. So here, this is a very important stipulation for me, which is the main purpose of my contract. So this is known as condition. This is known as condition. Now, what if the condition is breached then? Condition is breached means, let's say seller claimed Seller gave me a statement, gave me stipulation, yes madam, this is India Gate basmati rice. But after eating it, I found out ki no, it is not India Gate basmati rice. So can I cancel the contract? Yes, I have right to repudiate. Repudiate means right to cancel the contract. Can I cancel the contract? Yes, I can cancel the contract because condition is breached now. Condition is very important for a contract. Can I cancel? Yes. And can I claim damages? Yes. If I suffer any loss because of breach of condition, I can claim damage also. Are we clear with this? This is known as condition. Now, let's understand warranty. Sometimes seller makes some stipulations and some statements which are less significant, which are not that main purpose, which are collateral to the main purpose, and they are known as warranty. And in case of breach of warranty, now you get only right to cancel. You don't get right to repudiate the contract. You don't get right to cancel the contract. You only can claim damages. You cannot you cannot cancel the contract. You can only claim damages. I'll explain you. Let's say I purchase earphones. Okay, so I purchased earphones, and the seller said ki for 1 year, this earphones will not damage. I purchased earphones. Listen very carefully. I purchased earphones. Seller said to me कि for 1 year this earphone will not get damaged. This earphone will work for at least 1 year. If this earphone stops working in this 1 year, then we guarantee you it will not stop working in the 1 year. If it stops working within 1 year, then either we will repair it for you or we will replace it for you. So this statement is given by the seller. Seller said me that this earphone will not damage and will not stop working for next 1 year. This is warranty. Now please understand, if let's say after 6 months one side of the earphone stopped working, now the question is, can I cancel the contract? The answer is no. Why? Because this is not condition. This is just a warranty. This is not main purpose. This is collateral to the main purpose. So this is just warranty. So here, can I cancel the contract? The answer is no. Why? Because this is not condition, this is warranty. But can I claim damages? The answer is yes. Damages means I will send these earphones back to them. Either they will repair it for me, repair it for free within the warranty period, they will repair my earphones, or if it is non-repairable, then they will replace this earphones with the new earphones, and they will replace me and give me the new earphones. Are you understanding, guys? I'm really sorry. I'm really sorry. Okay. Are you understanding? This is warranty. So warranty ke breach ke case mein you cannot cancel the contract. Can you say after 6 months of using the earphones, can you say take your earphones back and give my money back? No, you cannot cancel the contract just because of the breach of warranty. But yes, if warranty is breached, definitely you can claim your damages or the whatever loss you have suffered. For example, this phone may I got warranty of 1 year. So if something happens, or if some app stops working in 6 months or within 1 year, then I cannot cancel the contract. I cannot say ki, no, you keep your phone back and return my money. No, you cannot cancel the contract, but I can get it repaired for free, or they will replace. If it is non repairable, they will replace it for me, so I can claim damages. Are you understanding? So any stipulation made by the seller which is very important or main which is for the essential for the main purpose, they are known as condition. And if condition is breached, then you can cancel the contract also, you can claim the damages. But there are some stipulation made by the seller which are less important, which are not main purpose but which are collateral to the main purpose. They are known as warranty. And in case of breach of warranty, you can only claim damages, you cannot cancel the contract. This is very important to understand. I hope you have understood this section 12. If you have understood section 12, we can read it from the material. Guys, if you will see now, this whole page I have summarized here. If you will see this chart now, this chart may this whole page is summarized. Same thing is literally repeated again and again. Something went to my eyes. Okay, this same thing is repeated again and again. We'll just read it and then we will highlight it later. Okay, acha, till here, this and this, whatever is given here, we have already understood through this chart. So now we have understood this. Let's read it from the material. Come to the material, page number 3.27, introduction, conditions and warranty. See, at the time of selling the goods, when seller is selling the goods, seller usually makes certain statements. Seller makes a lot of statements. So, while selling, seller tells you a lot of things about the goods. So, seller makes a lot of statement with a view to induce the intending buyer to purchase. Why he makes a statement? So that buyer will purchase. Such representations are generally about the nature and quality of goods. Bakwas is given, no need to underline. General points are given, not relevant from examination point of view. Next, when the statement and representation do not form a part of the contract, they are not relevant and they have no legal effects on the contract. But when this forms a part of the contract, the buyer relies upon them and they are relevant and have legal effects on the contract of sale. What they are trying to say is some statements are not a part of the contract. That means they have no legal effects. Simply seller is saying, oh, you are looking like a Katrina Kaif in this dress. This is just his opinion. This have no legal effect. Some some form part of the contract. That means buyer relies upon them and they have legal effect. For example, you claimed ki this is India Gate basmati rice. I relied on you ki yes, this is India Gate basmati rice. That's why I purchased it. Otherwise, I would not have purchased it. So this have legal effect and they are known as condition and warranty. Now, a representation which forms a part of the contract of sale and affects a contract is known as stipulation. Now here the definition of stipulation is given. What do you mean by stipulation? Those representation which form a part of the contract. Those representation which form the part of the contract of sale is known as stipulation. Now, stipulation is of two types. Some stipulations are known as conditions and some stipulations are known as warranties. So please understand here, however, every stipulation is not of equal importance. Some stipulation are very important and some stipulation are less important. So some of this may be very vital. Vital means important, while others may be lesser significance. Lesser significance means lesser important. So the more significant stipulations are called as conditions, while the less significant stipulation are known as warranty. Very nice line is written ki more significant stipulation have been called condition. However, less significant stipulation have been called warranty. So this is the basic history, basic introduction of condition and warranty is given. Now section 12. Section 12 talks about condition and warranty. Same thing is given, only section 12 says that stipulation is the contract with reference to the subject matter may be condition of warranty. So what they are saying to you, ki stipulation may be condition of warranty. A stipulation is of two types. It may be a condition or it may be a warranty. What is a condition? Definition of condition and definition of warranty is given. Condition is a stipulation which is essential to the main purpose of the contract, the breach of which gives rise to right to treat the contract as repudiated. Repudiated means cancelled. Pencil, bol pencil, your contract cancel. Are we clear with this? So what do you mean by condition? We have already understood condition means which is essential to the main purpose of the contract, and if breach, you get right to cancel also and you get right to damages also. So here one point is given ki condition is essential to the main purpose of the contract and the breach of which gives rise you to treat the contract as cancelled. In case the seller breached the condition, then you can cancel the contract. Okay, simply example. One example is given ki P wants to purchase a car from Q which can have the mileage of 20 km per liter. Q pointing at a particular vehicle says this car will suit you. Later P buys a car but finds out that it has only mileage of 15 km per liter. This amounts to breach of condition because the seller made the stipulation which forms the essence of the contract. In this case, mileage was the stipulation that was essential for the main purpose. What is given here? There is a buyer and there is a car showroom. There is a car showroom. So a lot of cars are there. Lot of cars are there. Oh, I have become expert in making cars. See how beautiful. Okay, so let's say a lot of cars are there in a car showroom and this is the seller. This buyer specifically said ki I need a car with a mileage of 20 km per liter. Please give me that car which has the mileage of 20 km per liter. So buyer specifically made the conditions. Buyer specifically told the seller ki I want that car only which gives the mileage of 20 km per liter. Now seller said ki oh, this car will suit you, you can buy this car. Okay, and then buyer purchased that car. Later on, buyer found out that this car only gives the mileage of 15 kilometer per liter. It does not give mileage of 20 kilometer. Please tell me whether condition is breached or not. The answer is yes. Is this is this a condition or not? Mileage of 20 kilometer per liter, yes, this is a condition, because buyer specifically told to seller ki I want that car only which gives mileage of 20 kilometer per liter, and seller said ki ha, this car will suit you. This car, seller specifically said ki this car gives a 20 kilometer per liter ka mileage. Now this is a condition. Is it a condition? Yes, because it is essential for the contract. Guys, please understand, is it a condition? Yes. Why? Because this is essence of the contract. This is very essential. This is main purpose of the contract, because buyer ka main requirement was ki car should have mileage of 20 kilometer per liter. So is this condition? Yes. Now later when buyer found out that this car gives only 15 kilometer per liter ka mileage, so can we say that condition is breached? The answer is yes, condition is breached. Can he return the car and get his money back? The answer is yes. Can he cancel the contract? Yes. Can he claim the damages? The answer is yes. Why? Because condition is breached. I hope you are clear with the meaning of condition and example. Okay, the next is warranty. What do you mean by warranty? So warranty is also a stipulation which is not the main purpose but which is collateral to the main purpose, and the breach of which give right only to claim damages but not the right to reject the goods and treat the contract as repudiated. In this, you can only claim damages, you cannot cancel the contract and you cannot return back the goods. So where the stipulation is a condition of warranty depends on each case. So now the question is whether any stipulation will be condition or warranty. It depends on case to case. It depends on the terms and conditions of the case. So a stipulation may be condition, though called a warranty in a contract. So it depends on terms and conditions, and it depends upon the contract basis. Each different contract, some stipulation may be condition and some stipulation may be warranty. Whether it is condition or warranty differs from case to case, and it depends on the condition. Now warranty ka one example is given. For example, Ram consult Shyam, a motor car dealer, for a car suitable for the touring purpose to promote the sale of his product. So here Ram said to Shyam कि I want to purchase a motor car. That car should suit the touring purpose. Touring purpose means I have to travel a lot. I have to keep on traveling a lot. Let's say from Chhattisgarh to Bihar, Bihar to Delhi, Delhi to Bangalore. I have to do road travel a lot. So suggest me that car, which is suitable for touring purpose. Okay. So Syam suggested Maruti. Syam suggested you can buy Maruti. Maruti is suitable for touring purpose. So Ram accordingly buys it from the Syam. The car turns out to be unfit for the touring purpose. Here, the term car should be suitable for touring purpose is a condition of the contract. It is so vital that its non-fulfillment defeat the very purpose for which Ram purchased the car. Thus, he is entitled to reject the car and refund. This is example of condition and not warranty. Please understand, there is a person called Ram and there is a person called Shyam. Ram specifically mentioned कि I want a car for touring purpose. I have to travel a lot. So Shyam said you can buy Maruti. Okay, Shyam said you can buy Maruti. Maruti is suitable for touring purpose. So here, please tell me, if later on Ram finds out कि no, this is not suitable for touring, this Maruti car is not suitable for touring, can he cancel the contract? So the first question is कि whether this car should be suitable for touring purpose is a condition or not. The answer is yes. This is the important condition. Why? Because this is the main purpose now why Ram purchased car. Ram ka main purpose of purchasing car was touring purpose. He was purchasing car for touring purpose only. So is it very important? Yes, Ram ke liye to it's very important na ki car should be suitable for touring purpose. That's why he is purchasing the car. So is it condition? Yes. Now if the Maruti car is not suitable for touring, can we say that condition is breached? Yes. In that case, can he return the car and claim a refund? Claim the refund? The answer is yes. He can cancel the contract, he can repudiate the contract, he can return the car and get his money back, because this is a breach of condition. Okay, now a breach of warranty example, same warranty wala repairing and all, earphones wala warranty wala, you can remember warranty ka example. Okay, now let us assume now they have changed the scenario. This same example may some other scenario. Okay, Ram buys a new Maruti car from the showroom and the car is guaranteed against the manufacturing defect under normal uses for a period of 1 year. Now ignore that touring purpose wala and all, ignore that. Fresh example, there is this person called Ram. He bought a Maruti car from the seller. Okay, now this car में 1 year का warranty was there, 1 year का warranty from manufacturing defect कि 1 year के अंदर if anything happens we will rectify the defect. So please understand, we are doing an example कि Ram buys a Maruti car, Ram bought a Maruti car from the showroom and the seller said that car में we are giving you guarantee against manufacturing defect under normal uses for a period of 1 year. So seller said कि 1 year की we are giving you guarantee कि against any manufacturing defect. So it will not happen anything, car will work properly for next 1 year from the date of the purchase. And in the event of manufacturing defect, there is a warranty for replacement of the defective part if it is not repaired. So what the seller said कि this car 1 year की guarantee we are giving you कि 1 year के अंदर no manufacturing defect will happen, and in case any manufacturing defect happens, then we will either repair it or we will replace it for free. Okay, so seller made this condition. Now what happened? Ram purchased a car. Now after 6 months, Ram found out some defect in the car. So after 6 months, Ram finds that horn of the car is not working. After 6 months, Ram found that horn is not working. Here in this case, can he cancel the contract? The answer is no, because horn is not working. That is not the main purpose of the contract. It is just a collateral. So it is not a condition, but it is a warranty. So this is, we will say this is breach of warranty. In this case, you can max to max claim damages. You cannot cancel the contract, which means the Maruti car or the seller will repair your horn for free or they will replace your horn. But can you return the car and claim the refund? The answer is no, you cannot cancel the contract. So here one point is given. In this case, he cannot terminate the contract. The manufacturer can either get it repaired or replace it with a new horn. Max to max, you can get it repaired or replace it with a new horn. Ram gets the right to claim the damages, if any, suffered by him. And if he suffers any damage, loss, then he can claim the damages, but he has no right to repudiation. No right to repudiation means he have no right to cancel the contract. So this is the example of warranty. This is the example of warranty, and this is the example of condition. Are you understanding, guys, warranty wala? So if you have understood now, it will be very easy for you to do the difference between the condition and the warranty. Two difference between is given. What is the difference between condition and warranty? Condition are those stipulation which are essential for the main purpose of the contract. As we know कि condition are very essential कि इसके breach के case में you can cancel the contract. But warranty are those stipulation which are collateral to the main purpose. These are not the main purpose, but these are collateral to the main purpose. What is this? Definition only. So this you can write from the definition only. Next, aggrieved party can repudiate the contract or claim damages or both. In this case, you can repudiate the contract also, or you can claim damages also, or both. But in this, aggrieved party can only claim damages and he cannot repudiate the warranty. Warranty के case में, I purchase earphones, one year की warranty is there. If 6 months में it stops working, I can get it replaced or repaired, but I cannot return the earphones and claim my money back. So warranty के case में you can only claim damages, you cannot repudiate the contract. Conversion of stipulation, guys, a breach of warranty may be treated as a breach of condition may be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. Guys, this point I will explain you in the next topic. This point you will understand in this topic, condition to be treated as warranty. As of now, please learn, digest this, कि breach of contract can be treated as breach of warranty, but breach of warranty cannot be treated as breach of contract. As of now, just learn this. We will understand this in the next topic. With this, we are done with the difference between conditions and warranty. Now, okay. Now, section 13, next topic. Guys, with this successfully, I hope you are clear with the meaning of condition and warranties. Now we'll be doing next section, that is section number 13. Section number 13 tells you the 4 cases where even if there is a breach of condition, but it will be treated as breach of warranty, which means condition is breached. Buyer can repudiate the contract, but no, we will not treat it as a breach of condition. We will treat it as breach of warranty. That means in that case, buyer cannot cancel the contract. He can only claim damages. So what are those cases that we will do here, where breach of condition will be treated as breach of warranty? So there are 4 cases, 1, 2, 3, 4. 4 cases where breach of condition will be treated as breach of warranty, and this is given in section number 13. 2 cases are known as compulsory waiver, a voluntary waiver, and 2 cases are known as compulsory waiver. One by one we will understand. Please understand voluntary waiver. Voluntary waiver means buyer himself voluntarily says ki, oh, let's waive the performance, it's fine, I will not treat it as a breach of condition, I will not repudiate the contract, I will treat it as breach of warranty. Let's understand this with the help of example. I went to shop and I said, I want India Gate Basmati rice. I went to the shop, I said, I want only India Gate Basmati rice. I want only this brand wala rice, India Gate Basmati rice. Shopkeeper gave me rice. Acha, is this condition? The answer is yes. This is my main purpose of buying rice. Now, why I am buying rice? I eat only India Gate Basmati. I have specifically told them the brand name. Ki, oh, give me only India Gate Basmati rice. So, is this condition? Yes, this is condition. Now, if they supplied me rice, I got the rice ka bag. This is rice ka bag. Later, I got to know this is not India Gate Basmati rice. Can I cancel the contract? The answer is yes. Because there is a breach of condition. I can cancel the contract, I can return their rice, and I can take my money back. But wait, let's say they made this rice, they gave this rice to me. I cooked this rice and I tried this rice. Although after trying this rice, I found out that this is not India Gate Basmati rice. So I found out this is not India Gate Basmati rice. So there's a breach of condition. Can I return the rice? Yes, I can. But let's say after eating this rice, I found this very tasty. And I found this even tastier than India Gate Basmati rice. So I thought, it's okay. I like it. Matlab, this rice is also good. After tasting it, voluntarily I decided ki, oh, this tastes even better than India Gate Basmati rice. So voluntarily I said to shopkeeper ki, theek hai, even if you breach the condition, then also I don't want to cancel the contract. I will keep this rice only, even if it is not India Gate Basmati rice. Even if you have breached the condition, then also it's fine. It's fine, I forgive you. I will keep this rice only. It's fine. This is known as a voluntary waiver by the buyer. So here, even if there is a breach of condition, but buyer is saying, no, it's okay, I will keep this rice, I will not cancel the contract, I will treat this breach as a breach of warranty, I will not cancel the contract. So here, buyer is voluntarily treating breach of contract condition as a breach of warranty. Here, buyer is voluntarily treating breach of condition as a breach of warranty. Are you understanding? So in which cases condition will be treated as warranty? Number one, if buyer waives the performance of the condition. What was the condition? Ki that rice should be India Gate Basmati rice. Buyer himself waived the performance of the condition. Ki theek hai, chalo, this rice is also good, it's fine even if it is not an India Gate Basmati rice. In that case, he himself said ki I will not cancel the contract, I will not treat it as a breach of condition, I will simply treat it as a breach of warranty and you can give me the compensation. That's it. Okay. Second case, if buyer himself elect to treat condition as warranty, you know what? Indirectly na 1 or 2 ka matlab same hai. My name is Ishika Agarwal. Myself Ishika Agarwal. Both mean same, right? Just statements are different. The same thing is only. I teach business law. Business law is being taught by me. Active, passive. Khatam. Are you understanding? So please understand this point number 1 and point number 2 are almost similar. Almost similar. Ki buyer himself elect to treat the condition as warranty. Buyer said to treat the condition as a warranty. For example, that mileage wala. Car mileage wala, remember? Car mileage wala. Example. Yes. The buyer went to the shop and said that give me a car which is giving a mileage of 20 kilometer per liter. Okay, so he gave me a car. He said ki buy this car. This car gives you 20 kilometer per liter ka mileage. Is this a condition? Yes. So for buyer, he specifically said I want 20 kilometer mileage wali car. So this is a condition, it's very important. And seller gave a car. Later buyer found out ki it is not giving 20 ka average, it is giving 15 ka average. Is this breach of condition? Yes. Can he cancel the contract? Yes. But let's say this car was cheaper. Let's say this car was cheaper, so he himself treated ki it's fine, let's not cancel the contract, this car is also fine, even if it is giving only 50 kilometer ka mileage, it's fine. Even if it's giving 15 km mileage, it's fine. Let's not treat it as a breach of condition. Let's accept this car only. So here he voluntarily said, buyer voluntarily said he elect to treat condition as a warranty. I will treat it as a warranty only, just give me the damages, that's it. Just give me the damages. So these 2 points are similar, only where voluntary waiver means buyer voluntarily waived his condition. He voluntarily waived his condition and said that it's okay, I will not treat it as a condition, I will treat it as a warranty, and I will not cancel the contract. Okay, so these are voluntary waiver. And two are compulsory waiver, where compulsorily condition will be treated as warranty. These two are compulsory waiver. Compulsory waiver means compulsorily conditions will be treated as warranty. Now we will do point number 3 and point number 4. Please understand point number 3. Point number 3 says that if contract is non-severable, severable means separable. Separable means when you can separate two things. Non-separable means you cannot separate two things, and buyer has already accepted either whole or part in goods. Let's take an example. My friends ordered a cake for my birthday, and I love blueberry cheesecake. Blueberry cheesecake. So my friends ordered blueberry cheesecake. This cake should be only blueberry cheesecake. They ordered which cake? They ordered blueberry cheesecake for my birthday. Okay, now is this a condition? Yes, now they ordered blueberry cheesecake. That cake should be blueberry cheesecake. Okay, now let's say on my birthday I'm cutting the cake. So I cut how much? One piece cake, and then I tried that one piece cake. As soon as I tried that cake, I found out ki oh, it is a pineapple cake. It is not a blueberry cheesecake. It is a pineapple cake. Now please understand. Can you return this cake? If you will see logically, you will say, ma'am, condition is breached. Ma'am, what was the condition? Ki this cake should be blueberry cheesecake. It's condition, yes, now they specifically ordered blueberry cheesecake, so obviously it's a condition. And they delivered pineapple cake instead of blueberry cake. We ordered blueberry cake, they delivered pineapple cake. Condition is breached, yes. Can we cancel the contract? Yes, we can. Can we return the cake? Yes, we can return the cake and we can claim our money back. But wait, what happened? Already, people started playing with the cream of the cake, and this two-piece we have already cut from the cake. Now how much is remaining? Only this much part of the cake is remaining. Only this much part of the cake is remaining. Can you return this? How will you return is, guys, some part of the cake we have already eaten and we have already used, and this and the other part is non-separable. So now there is no, now you cannot return it because you have already used some part of the good and it is not separable, so other part you cannot return. Are you understanding? So even if it's a breach of condition, you have right to return, but since you have already used that good, now you cannot return it. Now you cannot cancel the contract. Max to max is you can claim damages, and this is where breach of condition will be treated as breach of warranty if the buyer has already accepted the whole or part of the goods, and it is non-separable. It is non-separable from the other part. For example, we have already eaten half of the cake and it is not separable from the remaining other. In this case, breach of condition will be treated as breach of warranty, because now this cake we cannot return because we have already used half of the cake. We have already eaten half of the cake now, so we cannot return it. So we cannot treat it as a breach of condition. So here breach of condition will be treated as breach of warranty. Okay, and last point, where condition is excused by law or impossibility. Excused by law means either it became unlawful or it became impossible to perform. Okay, let's take an example. um, mm, 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 mm. Okay, um, let's say you have put some condition on the contract of sale, but now that condition cannot be performed because of the law or impossibility, means either it has become illegal or it has become impossible. Let's take an example. I ordered some um, food items from you, or let's say some packing material from you. Okay, I ordered some packing plastics. So I packing material, and I said that that packing box should be of the plastic, not of the cardboard. That packing box should be of the plastic. So I put a condition ki give me packing box, and that packing box should be made of plastic, not of cardboard. Now what happened? Before you could make the delivery, government banned plastic, government banned use of plastic box, government banned use of plastic box. Government said that you cannot sell plastic box, you can only sell either wooden box or the cardboard wala box or paper wala box. You cannot sell plastic box. So now we did a contract where I put a condition ki you deliver me only plastic box. So that was a condition. But later on what happened, government banned use of plastic. So as a result, you could not send me plastic box. Instead of the plastic box, you gave me the cardboard or a paper wala box. You gave me paper wala box. So now condition is breached, yes, but since it is breached due to law, because law did not allow it to, it became unlawful. Are you understanding? Because law is changed, it became unlawful. So they cannot send me plastic box because government banned it. So now in this case, it's not their fault. This condition is excused by law or impossibility. So here it is not the fault of seller. So in this case, I cannot cancel the contract. I can max to max claim damages. So here, even if there is a breach of condition, but it will be treated as breach of warranty. Okay, so we have done this case, section number 13, where breach of condition will be treated as a breach of warranty. 2 voluntary waiver case are there, and 2 compulsory waiver case are there. Let's read it from the material very quickly. Come here, when condition to be treated as warranty. So if you'll come here, section number 13. Section number specifies cases where breach of condition to be treated as breach of warranty. 4 cases are given where breach of condition will be treated as breach of warranty, as a result of which buyer loses his right to resign the contract. Resign means cancel the contract, and can claim damages only. So even if in these cases there is a breach of contract, but sorry sorry, even if in these 4 cases there is a breach of condition, but we will not treat it as a breach of condition, we will treat it as a breach of warranty. That means we cannot cancel the contract. Max to max we can claim damages. Okay, so in the following cases, contract cannot be avoided, which means contract cannot be cancelled even if there is a breach of condition. How many cases are there? 1, 2, 3, 4. 4 cases are there, one by one, where the buyer altogether waives the performance of the condition. A buyer may, for his own benefit, waive the stipulation. Where the buyer simply waives the performance of the condition, maybe for his own benefit. That rice wala example, I ordered India Gate Basmati rice. That was a condition. You delivered me some other rice. Is this a breach of condition? Yes. But I liked that rice even more than India Gate Basmati rice. So for my own benefit only, I waived the condition. Okay, it's fine. I will not cancel the contract. I will treat it as a breach of warranty. Why? Because buyer waived the performance, maybe for his own benefit. Point number 2, where the buyer elects to treat breach of condition as a breach of warranty. Same point, only 1 and 2 point are similar. Ki buyer himself says ki okay, I will not cancel the contract. I will not treat it as a breach of condition. I will treat it only as a breach of warranty. That is to say, he may claim only damages instead of cancel the contract. Okay. For example, A agrees to supply B 10 bags of first quality sugar at the rate of 625 rupees per bag. For example, example is given ki A is the seller. He said to B ki I will supply you 10 bags of first quality sugar. First quality sugar, which is at the rate 625 per bag. Okay. Now what happened? But he supplies second quality sugar, which is worth rupees 600 per bag. Now, please understand, sugars are also of different quality, like top quality, first quality, second quality. Now, what happened? First quality ka price is 625 per bag, and second quality ka price is 600 per bag. A agreed to sell first quality sugar to be at the price of 625 per gram. But what happened, instead of first quality sugar, he supplied second quality sugar. Now what happened here, there is a breach of condition. Yes, there is a breach of condition. Why? Because buyer wanted only first quality sugar. Now let's say later buyer thought कि ठीक है, second quality sugar also tastes fine, it is also good, and I will save my 25 rupees. So later on buyer thought of treating a breach of condition as a breach of warranty, and he said कि ठीक है, I can keep the second quality sugar only and I will pay you 1600 rupees for the second quality sugar. So here buyer, for his own benefit, he voluntarily decides to treat breach of condition as a breach of warranty without cancelling the contract. This is also a treating breach of condition as a breach of warranty. So here there is a breach of condition and buyer can reject the goods, but if buyer so elect, he may treat it as a breach of warranty. Hence he may accept the goods, second quality goods, and claim damages of 25 per bag. So if he want, he can claim this, he can accept the second quality goods. In that case, whatever loss he incurred, he gave 25 rupees extra per bag. He gave 625 rupees, but he received second quality sugar which is worth rupees 600, so he will get 25 rupees per bag ka refund or damages back. Are we clear with this? Third case, where the contract is non-severable and the buyer has accepted either whole or part of the goods. Example, that cake wala example, remember that cake wala example I gave you? In that case also, breach of condition will be treated as breach of warranty. Why? Because you cannot return the cake, you cannot cancel the contract because two pieces of cake you have already eaten. One more example is given. For example, basmati rice and lower quality rice mixed together, the contract becomes non-severable. Let's say there is a seller, he mixed basmati rice with a low quality rice, he mixed them all together and he sold it to me. So here guys, we have already accepted the goods and it is non-severable. Contract is non-severable means we cannot separate that good quality basmati rice and bad quality rice. We cannot separate it. It's not separable, and we have already accepted the consideration. Then in that case, we cannot cancel the contract. We can only claim damages. So in this case, breach of condition will be treated as breach of warranty. Last point, where the fulfillment of condition is excused by either law or by impossibility or otherwise. If you cannot fulfill the condition of warranty because it has become impossible or it has become illegal, either by law, if it is excused by law, or impossible. Example, that plastic wala example I gave you, na, plastic box wala, that you can use here. Same thing is given here, and with this we are done with your section number 13, in which case breach of condition will be treated as breach of warranty. Now guys, okay, so we'll be continuing now. One small thing before moving to the next topic, that we studied about conditions and warranties. So this unit is more about conditions and warranties. So these conditions and warranties can be express also, implied also. We already know what do you mean by express, implied. Express means when it is expressed by words, when it is expressly provided in the contract, either orally or in writing. Implied means which is understandable, which is not provided in the contract, but which is incorporated by law, which is understandable. For example, if let's say I'm selling food, then it is understandable, it is implied condition ki that food should be eatable, there should not be insects or any fungus in that food. It is pretty obvious, it is imposed by law. This condition need not be incorporated in the contract. If I'm selling you let's say dosa, us dosa mein insect should not be there, cockroach should not be there in that dosa, that's the implied condition. So what I'm trying to say is conditions and warranties are express, also implied also. Express means which are expressly written in the contract. Implied means which are not written in the contract but which are understandable, which are implied by law. But this implied condition can be waived by express agreement, meaning if you don't want any implied condition to apply, then in your agreement you can write ki any implied condition and warranty will not apply. So implied condition can be waived by writing in an express agreement. This is about express and implied. So where it is given here, here condition and warranty, express and implied. So here chotu sa very small sa point is given ki condition and warranty may be express or implied. Express means when they are given in the contract, implied means when they are not given in the contract. Simply express means Okay, same thing is written here, I guess. Express conditions are those which are agreed upon by the parties at the time of contract and are expressly provided in the contract. Express name itself suggests that parties have expressly decided it in the contract by using words. And what do you mean by implied condition? Implied condition means which are presumed by the law, which are assumed. It is pretty obvious. It is assumed by the law to be present in the contract. It should be noted that implied condition may be negated or waived by express agreement. This all thing is given in the notes also, which means we are saying that implied condition may be negated or waived by the agreement means if you don't want implied condition to apply, then you can waive it off in the agreement. From the in the agreement you can write ki implied condition will not apply to us. Okay, so conditions are also two type, express and implied, and a warranty are also two type, express and implied. If you will come here now there is a topic of implied condition which is very important. 1 2 3 4 5 6 7 7 type of implied conditions are there. If you will see this 7 type of implied condition, after that if you will come to page number 3.34, there is a topic called implied warranty. Implied warranty, so these two topics are very important. These two topics, after that consider your lesson done. Implied condition and implied warranty. Implied condition and implied warranty. Okay, now come here. As we have already studied, key conditions and warranties can be expressed, means which are expressly decided by the parties, and implied means which are assumed by law, which is presumed by law, which is pretty obvious it will be there. It are not expressly given in the contract. Now implied conditions are 7 types: 1 2 3 4 5 6 and 7. Okay, and implied warranty are 4 types: 1 2 3 4. After this your unit is done, but this is your major mountain. Okay, and important implied conditions and implied warranty. KV tempter is very easy, repeated topic only. KV tempter anyway it will be covered with implied condition only. So okay, first we will do implied conditions. Implied conditions, so we have already done conditions and warranties are two type, express and implied. So we are going to study what are implied conditions and what are implied warranties one by one. Implied conditions means it is assumed, no need to write it in the contract. These conditions are assumed, no need to expressly write it in the contract. The first implied condition is condition as to title. Condition as to title means I should have the title of the goods if I am selling it. Title means ownership. Title means ownership. Remember I told you title, ownership, property all mean same, which means if I am selling this phone to you, I should have the title of this phone. That means I should be the owner of this good. I should have the title of this goods. Then only I can sell this goods to you. So that is known as condition as to title. It is given in section 14A. This says that seller should have the title, that is right to sell the goods at the time when ownership has to pass. When I am giving you ownership to you, I should have the ownership, then only I can give it to you. Now if I only don't have ownership, how can I give it to you? Meaning stolen device, guys. If I have stolen any property from someone and then I sold it to you, can I give you good title? No, because I don't have a title, I don't have the ownership, so how can I give it to you? So that is an implied condition that you should this is the implied condition that you should have the ownership of the goods. Now let's understand this with the help of example. Let's say there is the mobile phone. Okay, mobile phone. This phone belongs to Amitabh Bachchan. Okay, he lost his phone in the road. In the roadside, he lost his phone. Let's say there is this person Raju. Raju found that mobile phone. Okay, is he the owner? No. Or let's say Raju stole that phone from Amitabh Bachchan. Okay, now please understand what happened. What happened? Amitabh Bachchan has a mobile phone. Raju stole that phone from Amitabh Bachchan. Please tell me who's the owner of this mobile phone? Amitabh Bachchan is the owner of mobile phone. Raju is the owner of phone. No, he stole it. Now what happened? Raju sold this phone. Sold to Shamu. Raju sold this phone to Shamu. for, let's say, whatever price. Now when Amitabh Bachchan started inquiry, he found out that this goods, his phone is with Shamu. His phone is with Shamu. Now Shamu has to return that phone to Amitabh Bachchan. The answer is yes. Why? Because who has ownership? The question is, who has ownership of the phone, Amitabh Bachchan or Ramu or Shamu? Apply your common sense and tell me, who have ownership of this mobile phone, Amitabh Bachchan or Raju or Shamu? The answer is Amitabh Bachchan has ownership of this phone. Why? Because Raju stole that phone. So did he get the title? No, he don't have title. So if Raju does not have title of the mobile phone, then how can he pass good title to Shamu? He also cannot get good title, which means if Raju himself is not the owner of this mobile phone, then how can he transfer ownership to Shamu? He cannot transfer. Are you understanding? So in this case, sale did not happen. This is a breach of condition. This is implied condition that if you're selling something, then you should be owner of that. If you're selling a goods, then you should have a title of that. You should be owner of that, which means if it is a stolen good and all, then the implied condition is breached. Now in that case, of course, you can repudiate the contract. Shamu has to return this phone to Amitabh Bachchan, and let's say his phone ka he paid 50,000 to Raju, so he can ask for refund of his 50,000 from Raju. Along with that, he can also claim damages. Are you understanding? So if let's say Raju sold you stolen goods, then there is an implied condition ka breach. In that case, of course, Amitabh Bachchan is the rightful owner. The true ownership of this phone is with Amitabh Bachchan, so he can take his property back. What will Shamu do? He have already paid 50,000 to Raju. Now here we will say that there is an implied condition ka breach, and Shamu can claim the refund of whatever money he has paid to Raju. 50,000 he has paid, he can claim the refund of 50,000 from Raju. Along with, he can claim damages also. Are you understanding? So there is a implied condition as to title, which means seller, if I am selling this phone, then I should have the title. Title means I should have the ownership. That is, I should have right to sell the goods when ownership is to pass. Are we clear with this? This is condition as to title. You know what? This is implied condition. This same condition, this same stipulation is warranty also. This title is condition also, and it is warranty also. If you will come here now, implied warranty may. If you will come here, implied warranty may. See, warranty as to undisturbed possession. First wala you will see कि buyer shall have quiet possession of the good. Quiet possession means buyer will have right to enjoy the goods. No one can take that goods from the buyer. This is implied warranty also. Now please understand, what if it is a stolen good? Please understand, Amitabh Bachchan has a mobile phone. Raju stole that mobile phone from Amitabh Bachchan and sold that mobile phone to Shamu. For how much rupees? For 50,000 rupees. Now please understand, if Shamu is purchasing this goods, purchasing this mobile phone, then he has implied warranty. He has implied warranty of undisturbed possession. Please understand, if Shamu purchased this mobile phone for 50,000, then he has implied warranty of undisturbed possession, means he can enjoy that mobile phone without any disturbance. Undisturbed possession means no one can take that phone from him. No one can take that from him. Now let's say later we found out that this phone was stolen. This phone was never belonged to Raju. This phone Raju stole from Amitabh Bachchan, and Amitabh Bachchan took that phone from him. Is implied warranty breach? Yes. So in this case, can he claim damages from Raju? Yes, he can claim damages also, and compensation also from Raju. So you know what? This title wala thing is treated as both implied condition also and implied warranty also. Only the language is different. Otherwise, concept is same. Implied warranty says that if I am purchasing goods, then I have implied warranty as to undisturbed possession, means no one can take that goods back from me. Even seller cannot take that goods back from me. He has sold that goods to me. Now he cannot take that goods back from me. So I have warranty as to undisturbed possession. Okay. Now in case, let's say it is a stolen goods. For example, if it is a stolen goods and rightful owner took that goods back from me, then we will say that there's a breach of implied warranty, and I can claim compensation from the Raju, from the seller. Same is is the implied condition also. Condition means seller should have the title. That means he should have ownership while selling the goods to the buyer. Only then buyer will get the good title. Only then buyer will get the ownership. But if it is a stolen good, then buyer will get good title kya? No. In that case, we will say that there is a breach of condition and you can cancel the contract, you can return the phone, and you can claim the refund. You can claim the refund back. Okay, so first implied condition is done condition as to title. Come, let's read it from the book. Implied condition mein please come to first implied condition, condition as to title. A condition as to title. So what is given here? In every contract of sale, in every contract of sale, unless there is an agreement to the contrary, ignore this wala, unless there is agreement to contrary, ignore this as of now. Just read, in every contract of sale, the first implied condition on the part of seller is that in case of sale, seller should have right to sell the goods, and in case of agreement to sell, ATS, remember agreement to sale mein I will sell goods in future, he should have right to sell the goods at the time when property is to pass. Here one simply point is given ki I should have title. I should have title means I should have ownership if I am selling any property. Ownership means I should have right to sell. Only owner has right to sell. So in case of sale, sale means present sale, I should have right to sell. In case of agreement to sale means future sale. Future sale के केस में even if I don't have right to sell as of now, it's fine, but I should have right to sell future में when the sale has to happen, when the property has to pass. So I should have right to sell when the property has to pass. Acha, same thing ko they have given here in simple words. In simple words, conditions implied is that seller should have right to sell the goods at the time when property has to pass. If the seller's title or ownership turns out to be defective, now what is given here? See, very nice line is given here ki if the title or ownership of the seller turns out to be defective, it means here who's the seller? Raju is the seller. Raju is selling this phone to Shamu. Shamu is the buyer. Okay, so what is the implied condition? Implied condition is that Raju should have right to sell, which means Raju should be the true owner. Raju should have the title or ownership of the goods. Later on, we found out that this title of the seller is defective. That means he is not the true owner. He don't have right to sell this, or he is not the owner, or he doesn't have title of the property. It is stolen, let's say. Later on, we found out that the seller's title is defective. Then buyer must return the goods to the true owner. In that case, if we found out that this mobile phone belongs to Amitabh Bachchan, then buyer will return this phone to Amitabh Bachchan and he will claim his refund back from the Raju. He will claim his refund back and he will recover his price from the seller. This is breach of implied condition. Are we clear with this? Same example, let's do one example. Here one point is given ki A purchased a tractor from B and had no title on it. Who had no title on it? So here one point is given ki A sold a tractor to B. A is seller, B is buyer. Now please understand, this tractor does not belong to A. A is not the owner of this tractor. After 2 months, the true owner spotted the tractor. Let's say this tractor belongs to C. Okay, A sold this tractor to B. And sometimes after 2 months, he found out that tractor, he found that tractor and he identified, oh, ye to mera tractor hai, this tractor is mine. He said that, oh, this tractor belongs to me, this tractor is mine. Now he demanded it from A, held that A was bound to hand over the tractor to its true owner and A could sue B, the seller, without title for the recovery of the purchase price. Acha, wait, I just made one mistake. Here B is the seller and A is the buyer. So B sold a tractor to A. Okay, so B sold a tractor to A. And later on we found that this tractor belongs to C. B does not have the right title of the tractor. Later on C demanded the tractor. In that case, this is an implied condition that seller should have title. Now here seller has no title, the seller's title is defective, so we will say that there is a breach of implied condition. In this case, Mr. A can cancel the contract. So A can return the tractor to the rightful owner and he can take his money back from the seller. This is an example. Same example is example 5. You can just have a read over it. With this, we are done with the first implied condition. Now we will be doing Second implied condition. Second implied condition is sale by description. Please understand, sale by description means sometimes buyer describe a product either by its kind or goods or class or kind of goods or by its characteristics. Then the good sold should correspond to the description essential for identifying the goods ka kind or class or the characteristics. This is an implied condition. For example, if I went to a shop and I said that ki Anna, give me um, give me a face cream. Okay, give me a cream which we can apply on the face. Are we clear with this? Okay, so I went to a shop, I described a product. What product I described? I said to seller, I said that Anna, what happened to the camera? Huh, fine. So let's say I went to the shop. I said that Anna, give me a face cream, which we can apply on the face cream. And don't you think it is now implied condition that if I'm describing the product, I'm describing the characteristics of the product. That cream which we apply on the face, I'm describing the characteristics of the product. Then he have to give me the same goods. That goods should correspond to the same description. This is implied condition. Now let's say he has to give me face cream only. He has to give me a cream which we apply on the face. This is an implied condition. Acha, what if he give me some other cream? Let's say he gave me some cream that we apply in the body lotion. That is not for face ke liye, face is more sensitive now, so face ke liye separate cream is there. So let's say he gave me some cream which we apply on the feet, and that is not for face, that is for feet, that is not for face. He gave me that cream. Now can we say that implied condition is breached? Yes, it is implied condition na, ki if I'm describing you, ki Anna give me face cream, so give me face cream na, why are you giving me body cream? Are you understanding? So if I'm describing the product, then your good should be according to the description. This is implied condition. And if you will break the implied condition, then I can cancel the contract and I can claim my refund. For example, I asked face cream for you, from you I gave description of the characteristics or class of goods ki face cream dena, and you gave me body cream. Is there implied condition? Yes. Is there breach of implied condition? Yes. Now in this case, I can return your cream back and I can ask for my money back. Give me my money. I want to cancel this contract because there is a breach of implied condition. What is the implied condition? If the sale is done by description, then goods should be according to the description, which is essential for identifying the goods as per its characteristics or class or kind of. Characteristics means how it is used. Class or kind of goods means types of goods. Okay, are we clear with this? This is given in section 15. Very quickly come here, sale by description. Sale by description में वैसे तो बहुत बड़ा बड़ा it is written in exam के लिए ना, even if you study 1-2 line that will be fine. Here one point is given, sale by description में where there is a contract of sale of goods by description. If the sale is done by description, then there is an implied condition. If I'm describing your product, I want such kind of product. Let's say if I'm describing your product, I want a mobile phone which have four cameras, I want a mobile phone with a 4 camera. So I have given a description to you. Now you have to give me mobile phone with a 4 camera only, because this is an implied condition. If I'm describing you the product, then you give me that product only as per my description. This is implied condition. Okay, so there's an implied condition that good shall correspond with the description, which means good should be according to the description. That means if you contract to sell peas, you cannot compel the buyer to take the beans. This is just a, kind of a proverb. Ki, if I want peas, give me peas, now don't give me beans. Okay, so the buyer is not bound to accept and pay for the goods which are not in accordance to the description of the goods. If they are not according to my description, then I'm not bound to purchase it and I'm not bound to make the payment. And if you have given me wrong product, then I can cancel the contract and I can claim my refund money back because there is a breach of implied condition. Are we clear with this? Now this much is enough. Let's just read the other 2 paragraph also. Thus it has to be determined whether buyer has undertaken to purchase the goods by the description, that is whether the description was essential for identifying the goods. But where the buyer had sorry, where the buyer has agreed to purchase, if that is required and goods standard are not correspond to the description. Same, this paragraph ditto same, in another words they have given same here also, no need to read it again. Same what is given here is given here. So if you read the first paragraph, it's more than sufficient. So what we are trying to say, that if I'm describing you the product, ki product should be like this, ki I want such a pencil, Apple Pencil, which have the sensitivity feature, which have sensitivity touch feature. So in that case, if I'm describing you the product, then you have to give me the same product which correspond with the description. Otherwise, it will be treated as breach of condition, and I can cancel the contract and claim my refund money. So if the condition which goes to the root of the contract and the breach of it entitles the buyer to reject the goods, same thing is given here. Acha, doesn't matter whether buyer inspect them or not, doesn't matter. If it is not as per my description, then I can cancel the contract even if I have not inspected the goods. One example is given here. A at Kolkata sells to B 12 bags of waste silk on its way from Murshidabad to Kolkata. So A was traveling from Murshidabad to Kolkata. So he sold 12 bags of waste silk to B. So there is an implied condition that silk shall be such as is known in the market as waste silk. If not, then B can reject the goods. So what was the description? Description was waste silk. Silk ka bhi lot of types are there na. So A said ki this is a waste silk. This is a waste silk, and he sold that silk to B. Now you are giving a description. You are selling a goods by description ki this is waste silk. So that silk should be waste silk. This is an implied condition. Otherwise, if it is not waste silk, then it will be treated as breach of implied condition, and buyer can return your goods back and get the refund of the money. Are we clear with this? Okay. Now this is an example. Thus, however, the act does not describe description. Now what if we are doing that, if sale is done by description, then good should be according to the description. But what do you mean by description? It is not defined in the act. So here one point is given ki where the sale or the kind to which the goods belong have been specified. Here one point is given ki if how we can determine the whether it is description of the goods or not. We can give the description of the good either by class or kind of the goods. Class or kind of the goods. For example, Java ki sugar, Egyptian cotton. Are you understanding? Class or kind of the good means, let's say this is Banarsi sari. Banarsi sari. If I'm saying you, madam, purchase this is Banarsi sari, original Banarsi sari, then that should be original Banarsi sari. This is known as description by class or kind of goods. Are we clear with this? Otherwise, it will be treated as breach of condition. For example, Java sugar. If I'm saying you this is Java sugar and I'm selling you Java sugar, so it should be Java sugar. This is an implied condition by description. Okay. And if it is not Java sugar, then you can return the goods to me and I can you can claim the refund. Next, how you can give the description? Number one, you can give the description by class or kind. Next, you can give the description by characteristics. Characteristics means you can give the usage, for what purpose it is used. Remember face cream I said. Okay, for example, jute bales of a specified shipment, steel of specific dimension. You can give characteristics also. Okay, I want steel of this dimension, I want shirt, pant, I want 1 liter milk. You can give some characteristics also. So description, how you can give description? It can be given either by class or kinds of goods, or it can be given by characteristics. So this is also there in the note. See how you can give the description by class or kind or by characteristics. This is also there in the notes. Now it may be noted that the description in these cases assume that the form of a statement or representation as regards the identity of the particular goods by reference to the place of origin or mode of packaging, whether or not such statement is essential for the identity of goods is a question of fact, depending each case on the construction of the contract. Here one point is given ki whether a particular description is essential or not, it is a condition or not, it is based on question of fact. Question of fact means it depends on case to case, it depends on situation whether it will be condition or not. Okay, no need to do this, you can ignore this last wala paragraph. So in this now, whatever you can do, this first wala paragraph and this description wala, this and this paragraph you can do in this second topic, second implied condition, description, sale by description. Okay, so now third is your sale by sample. Sale by sample. Now sale by sample means, you know, sometimes now we sell certain goods by showing some sample. Let's say rice, for example. Rice comes of different quality rice, very top quality rice, thin rice, thick rice, chote chote rice, chickadoo rice, dodadu rice, different kind of quality of rice comes. Acha, do you check each and every rice before you purchase it? Let's say I have to purchase 10 kg rice. Will I keep on checking each and every rice? I will just see the sample. Are you understanding? I will just see the sample of all type of rice. So let's say I saw the sample of rice, I liked it, and I said that Anna, give me 10 kg rice. Okay, this is known as sale by sample. Acha, now don't you think if I saw the rice ka sample and I liked it, and I said that Anna, give me this sample wala 10 kg rice. Now the goods, the rice that he will give me should be same like the sample. ऐसा नहीं, it should not happen कि sample में some other rice is there and he gave me some other rice. Are you understanding? So if sale is done by sample, if you are selling me rice by showing the sample, then the goods that you will supply to me should correspond to the sample. Should correspond to the sample means it should be similar to the sample. What if, let's say, sample you showed me good, but actual rice you gave to me is very bad quality? Then it is known as breach of implied condition. In that case, I can cancel the contract, return your rice and claim my money back. Okay, so in case sale is done by sample, then sale should correspond to the good, should correspond to the sample, good should be according to the sample, and buyer should have the opportunity to inspect. And when you will give me, let's say, 1 kg rice or 10 kg rice, buyer should be given opportunity to inspect. And lastly, it should be free from any merchantable defects which could not be revealed on examination. Now, this third point I will explain you. It should be free from merchantable defects which could not be revealed on examination. It simply means hidden defects. Acha, merchantable defects means manufacturing defect. Merchantable defects means manufacturing defect which could not be revealed on examination. Matlab, this is defect, something which is hidden, which cannot be revealed on examination. For example, I'll give you one example. Listen very carefully, huh? Example, shoe wala example I use in this. Let's say there is a shopkeeper. Shoe shop. There is a shoe shop, there is a shopkeeper, and I want to purchase shoes. Okay, I'm the buyer. I want to purchase what? I want to purchase shoes. Now what happened? I want to purchase plastic shoes. Plastic shoe. Let's say rainy season is coming, and let's say I am running in a campaign. So in that campaign, 100 people are there. So for those 100 people, I want 100 pair of plastic shoe. I went to the shop and I said ki I want a plastic shoe. He showed me a sample. He showed me a sample of shoes. Very nice. Okay, so he showed me a sample, and you know, actual may this shoe is made of paper. But what they did, they coated this shoe with such a, you know, black and white painting and coating, and made such a shiny look that bahar se it's looking like a plastic. It is actually made of paper, but they did some painting and all in this shoe. You know, they did some polishing and painting and shining, that, you know, on holding and on look from outside, it is looking like a plastic. Okay, so the shopkeeper gave me this shoe. Okay, he showed me this sample. I said, ha, ye shoe to bahut acha. This shoe is exactly the same plastic shoe that I want. And I gave him order of 100 shoe. I gave him order of 100 shoe. This plastic shoe I saw, and I gave him order of 100 pair of shoes. 100 pair of shoes. I want 100 pair of shoes. Now he supplied me 100 pair of shoes. Now everyone started wearing that shoe, and when we went outside on the rainy season on water, what we saw that it is a paper and it all melted, and in no time that shoe is completely destroyed, torn. It was just a paper, it was not a plastic. So please tell me, is there a breach of implied condition or not? The answer is yes, it is a breach of implied condition. Why? Because this is sale by sample, and in this case this sample was not accurate, or the goods were not according to the sample, number one. Secondly, goods may there were merchantable defects, means manufacturing defects, which was not revealed on examination. Buyer checked the shoes, he did check the shoes, but even by examination he was not able to tell that this good is made of this shoe is made of paper and not plastic. There were hidden defects, there were hidden defects, so there was no fault of buyer. He did examine, but that defect was not revealed on examination. There were hidden defects in that. So in this case we will say that here there is a breach of implied condition, and here buyer can return all the shoes, all the 100 pair of shoes to the seller and claim the refund. So this is an implied condition, that if sale is done by sample, then goods should be according to the sample, number one. Number two, buyer should get opportunity to inspect. And number three, if there is merchantable defects, there should not be any, it should be free from means there should not be any merchantable defects which could not be revealed on examination, which means there should not be any hidden defects. That's all about sale by sample, section number 19. Now please come here to page number 3.31 last, sale by sample, section number 17. So in case there is a contract of sale by sample, there is an implied condition that the bulk shall correspond to the sample in quality. Quality mein what we are saying ki bulk should be according to the sample. Meaning, if you showed me sample of rice, example rice, that rice ka sample you showed me, I liked it. Now the 1 kg rice that you will send me should be according to the sample only, should be similar to sample only. Quality same hona chahiye, quality should be same, it should not be of different quality. Next, buyer should get reasonable opportunity of comparing the bulk with the sample. Buyer should get reasonable opportunity to compare the sample with the bulk. He should get opportunity to inspect ki haan, all the rice are good now. Next, it should be free from any defect rendering it unmerchantable, meaning it should not be it should not have any hidden defects, it should not have any merchantable defects. Merchantable means it's not usable, unmerchantable means it's not usable, merchantable means usable. It should not be, it should be free from those defects which will render them unmerchantable, which means, for example, shoe. What is the purpose of plastic shoe? The purpose of plastic shoe is to wear it in the rain and water so that it does not get spoiled. Okay, that's the purpose of plastic shoe. Now if it has the defect, let's say it is made of paper, it is not made of plastic, so it has a defect which makes it unmerchantable. Unmerchantable means it's not usable, the main purpose, it's not fulfilling the purpose. That shoe is made of paper, so it's not fulfilling the purpose. So what we are saying, that there is an implied condition that goods should not have any merchantable defects, it should be free from any merchantable defects. Okay, which would not be apparent, or which would not be apparent, apparent means visible, on the reasonable examination. Okay, it should be free from any merchantable defects which is not visible on the examination. So this condition is applicable only with regards to defects which could not be discovered by original examination. Guys, this condition is applicable only for hidden defects. Acha, what if let's say he sold me paper ke shoe by saying that it is plastic ke shoe, but even if you will hold it in hand, or by seeing only, anyone can tell this is paper ka shoe, this is not plastic ka shoe. So if the defect is clearly visible, then this is not an implied condition, your fault. Let the buyer beware, buyer's fault. It was clearly visible that it is paper ke shoe, why did you purchase it? But this condition is applicable only if it is not visible from ordinary examination. They painted it in such a way that it's actually looking like a plastic, and by ordinary examination you cannot tell ki it is made up of paper. Then this implied condition will be applicable, and you can return the goods, you can claim the refund of your money. So if the defects are latent, then the buyer can avoid the contract. Latent means hidden here. If the defects are hidden, if there are hidden defects, then buyer can avoid the contract. For example, a company sold certain shoes on a special sole by sample for a French army. So French army ke liye na company sold a shoe with a special sole. There was a special sole. Now shoe were found to contain paper, not describable by the ordinary examination. Now later they found out that shoe mein there is not sole, there is just paper, which you cannot discover by ordinary inspection. So in this case, buyer was entitled to claim the refund and the damages, and he can return the goods. This is known as sale by sample. This is an implied condition. Guys, implied condition is a little technical topic, but if you will do this with full concentration and you will read it again and again, you will definitely understood. Only implied condition is little technical, rest all topics are easy. Okay, so we are done with sale by sample. So fourth topic is similar, easy only, sale by sample and description. Now guys, we have already done sale by description and we have already done sale by sample. So sale by description is a separate implied condition, sale by sample is a separate implied condition. Now sale by sample and description, now it is combination of both. Now fourth wala case, sale by sample and description, this is combination of both, third wala also, second wala also. Are you understanding? So now what do you mean by sale by sample or description? For example, sunflower oil wala example I will take here, section number 15 mein. For example, I went to a shop. Shopkeeper said me ki madam, this is sunflower oil. Okay, so he gave description. What description he gave? This is sunflower oil. This is sunflower oil. And he showed me sample also. He took some oil in the spoon and he showed me thoda sa 1 spoon of oil. He showed me in my hands also. Okay, so he is selling me sunflower oil by giving description also and by giving sample also, which means he gave description ki ma'am, this oil is made of sunflower, this oil is made of sunflower. He gave me description also and he showed me thoda sa sample also. In that case, good should correspond to both sample and description. If seller is giving description and sample both, then good should be according to description and sample both. Otherwise, we will say that there is a breach of implied condition and I can return the goods and I can claim my money back. For example, let's understand this with the help of example. For example, okay, sunflower wala example I was telling you. Let's take an example ki he said me, he gave me a description ki it is sunflower oil and he showed me sample also. But you know what? Actual mein na, that oil was a mixture of 2-3 oil. It was a mixture of sunflower oil, olive oil, coconut oil, castor oil. It was a mixture of castor oil, all mixture na. So when he showed me sample na, that time it was mixture only. He showed me sample, that sample was mixture of all the oil. I did not identify, I thought it is sunflower oil only. Now he gave me that oil. After he gave me that oil, I found out ki, oh, it is not sunflower oil, rather it is mixed oil. It is mixture of castor oil, custard oil, etc, etc, etc. Are you understanding? Mustard oil, castor oil, olive oil, all the mixture. So now can I return the goods and can I return the oil and can I claim my money back? The answer is yes. Is the condition breached? Yes. We will say that there is a breach of implied condition. Now if the shopkeeper will say, madam, I showed you sample na, sample maybe though it was mixed oil. So it is the same which I showed you sample na, this is same. So shopkeeper will say, ma'am, shopkeeper will say ki goods are according to the sample. Oil is same as sample, but I will say it is not the same as description. Although you showed me sample, but you gave me description also ki this is sunflower oil. So it should be according to both. It should be same as both sample and description. If it is not as per the description, although it is same as the sample, but it is not the same as description. You gave me description ki it is sunflower oil, but actually it is mixed oil. So in this case also it will be treated as breach of implied condition and I can return his oil and I can claim my money back. So in case sale is done by sample and description both, then good should be according to sample and description both. If it is not as per sample or it is not as per description, then you can cancel the contract and buyer can claim the refund. Okay, this is your fourth what we will say, this is your breach of implied condition. Now please come to the material, sale by sample as well as description, section number 15, where the goods are sold by the sample as well as description. If you're selling the goods by both sample as well as description, then the implied condition is that there is an implied condition that the bulk good should correspond both with the sample and description. What we are saying that if you're showing sample also, giving description also, then the good should be according to both sample also, description also. In case goods are not totally as per the description or as per the sample, or vice versa, or both, then buyer can cancel the contract. Okay, Same example, what I give oil wala, same example is given here. You can just have a read over it. With this, we are done with 4 implied conditions, where even if this condition is not mentioned in the contract, but these are implied condition. If seller will break this implied conditions, then buyer can cancel the contract. These are implied condition. Till now what we did, condition as to title, which means seller should have the title of the goods at the time of selling it. Next, sale by description. If seller has described the product, then good should be according to the description. Sale by sample. If seller has shown the sample, then good should be according to the sample. Sale by sample and description. If seller has shown sample and description both, then good should be according to sample and description both. These 3 points are similar. Done. Next points. Condition as to merchantability. Condition as to merchantability. Guys, we are almost about to be done. Just 3 more implied conditions are there, which are little technical, and then implied warranty is easy. Implied warranty is like very easy. This you can easily do. KVA temperature is also repeated. This also you can easily do. Okay, so now fifth condition. Okay. Okay, so let's continue. The next implied condition is your condition as to merchantability, whatever you want to say. I think it's merchantability. Yes, merchantability. So condition as to merchantability. Merchantability means goods should be in such a condition that a person, ordinary person, would accept it, would use it. So merchantability means usable. Let's say if we talk about bottle, what is the main purpose of bottle? To hold liquid, right? The main purpose of bottle to hold liquid. So it should be of merchantable, means it should be usable. It should be usable. It should be free from defects. It should be usable. It should be free from defects, which a ordinary person can accept it and can use it. Now, for example, you are selling me this bottle. Now, from the bottom, there is a hole. From the bottom, there is a hole in this bottle, and you are selling me this bottle. Is this bottle merchantable? The answer is no. This bottle is not merchantable. Why? Because it is defective and it is not serving the purpose. I told you that I need a bottle to hold water. I need a bottle to hold water. Now in this case, how will this bottle hold liquid if bottom may there is a hole? There is a big hole in the bottom. How this bottle will hold water? This bottle cannot hold water, right? In that case, so we will say that this bottle is not merchantable. So this is a breach of implied condition. In that case, I can return the bottle to you and I can claim my money back. So there is an implied condition that your good should be merchantable, means it's usable. It should be as per the description. It should be free from defects. Are we clear with this? And if the goods are bought by description, let's say I describe the goods, I need a bottle of 1 liter to hold, let's say, water, and seller is dealer of goods of that description. Seller deals with bottle. Seller is the dealer of goods of that description, means seller deals with the water. Then good should be of merchantable quality. Good quality. It should be usable. It should be free from defects. Are you understanding? Let's say there is a crack in this bottle. There is a crack in this bottle from which water is leaking. So we will say that it is not merchantable quality. Merchantable quality means free from defects, usable. Are we clear with this? So there is an implied condition that good should be merchantable quality. Acha, but now let's say there is a crack in this bottle, but it is not visible. It is not clearly visible. There is a crack in this bottle. Okay. There is a crack in this bottle, but which is not visible very clearly. So is this bottle merchantable? No. Can I use this bottle? No, because water is leaking. There is a leakage of water from this. So I cannot use this water. So we will say that there is a breach of implied condition of merchantability, and I can return this bottle to the seller and I can claim the refund. But there is one exception where this implied condition will not apply. If buyer has examined the goods, let's say before purchasing this bottle, I did check this bottle properly from all the sides. I did examine the bottle, I did check the bottle, and that defect was clearly visible. For example, there was that crack in the bottle or that hole in the bottle was clearly visible. If if anyone having eyes would see that, he can easily find out that it is cracked or there is a hole in the bottle. So if a buyer has examined the bottle, if he has examined the goods and the goods is clearly visible, then also he bought the good, then buyer ki mistake, then this implied condition will not apply. Then you cannot return this bottle to the seller and ask for refund. The seller will be like, you did check the bottle and this crack was clearly visible, why you bought it? As a buyer you should be aware now. So we say na, caveat emptor. Caveat emptor means let the buyer beware. Let the buyer beware means before buying anything you should also check if it is proper or not. It is your responsibility to check any goods whether it is free from defects or not. So if buyer has examined the goods plus defects are clearly visible, defects could be easily revealed on examination. If you will check it now bottle from all the side, you can easily see there is a hole in the bottle, then there is no implied condition as to merchantability. In that case I cannot return the bottle, I will not get the refund. This is all about implied condition of merchantability. Let's read it from the material. Please come to page number 3.33. This condition number 6, condition as to merchantability. This is given in section 16 subsection 2. It says that where the goods are bought by description from the seller. If I am giving you description ki I need a bottle to hold water, I goods are bought by giving description from the seller. Who deals in the goods of that description? Who deals in the goods of that description means he sells bottle only. He sells bottle, matlab he deals in the bottles. Whether he is manufacturer or producer or not, doesn't matter, he's the manufacturer or not, he simply deals with it. He purchase and sell bottle. Then there is an implied condition that good should be of merchantable quality. Then there is an implied condition that good should be fit for the purpose. It should be usable. It should be merchantable quality. And there are two conditions. Number one, good should be bought by description. Guys, in order to impose this implied condition of merchantability, two conditions are there. One, it should be bought by description. And secondly, a seller should be the dealer in that goods. Matlab, he should be frequently dealing and selling in that goods. Now, provided that one exception is there. One exception is there. What is the exception? If the buyer has examined the goods and there shall be no implied condition as to merchantability as regard defect, which such examination ought to have revealed. Ought to have revealed means if on examination that defect can be easily revealed, in that case there will be no implied condition. Okay, now what do you mean by merchantability? Merchantability means goods of that quality and in such condition that a man of ordinary prudence means ordinary common sense, would accept them as a goods of that description. So what do you mean by merchantable quality? When a man of ordinary prudence would accept it, would accept that good, that is known as merchantable quality. For example, bottle. When we will say that bottle is of merchantable quality, when it is properly covered with lid, it is cylindrical shape, it has a bottom is covered, it is covered from three side. Are you understanding? There is a lid. So then we say that it is merchantable, it can hold water simply. Are you understanding? Then we can say when the goods are of that quality and condition which any man of ordinary prudence can accept it, then we call it is merchantable quality. For example, if a person orders motor horn from the manufacturer of horns, I purchased horn from the manufacturer of horn and that horn was scratched and damaged. In that case, that horn is unmerchantable. If let's say that horn is damaged, it's not working because of the bad packaging, then we will say that that horn is not merchantable and I can return that horn to you and I can claim the refund. This is condition as to merchantability. Okay, acha. Second last condition as to wholesomeness. Guys, just like it is same like merchantability, just like merchantability word is used for goods, similarly wholesome word is used for any eatables and provisions. For example, if you're buying biscuits, chocolates, food items, rice, wheat, anything eatable, anything which is eatable, pasta, Maggie, you went to a restaurant, you ordered pizza. So in case of eatables and provisions, simply there is an implied condition that good should be wholesome. Wholesome means eatable. Eatable means it should not have insect in it, it should be fresh, it should not be stale, it should not have fungus in it. Something which is eatable is wholesome. However, if that food is spoiled, let's say in that food it is 3 days old food, there is fungus in that, so it is not wholesome. Wholesome word is used for eatable, something which you can eat. Wholesome word is used for eatables. So whenever you are selling eatables or provisions, then there is an implied condition that it should be wholesome. If it is not wholesome, then there is a breach of implied condition, and then you can return that food and you can claim the refund. For example, I went to a restaurant, I ordered pizza. Pizza should be wholesome, means it should be eatable. Let's say I found out there is a cockroach in the pizza, then I can return their pizza to them and I can claim my refund. Why? Because there is a breach of implied condition. Very easy. This point is like super easy. Now please come here. Next condition, condition as to wholesomeness. So what is given here? In case of eatables and provisions, only in case of eatables and provision, there is another implied condition that good should be wholesome. Wholesome means eatable. For example, A supplied F with milk. A supplied milk. Milk contained typhoid germs. Oh my god, in that milk there were typhoid ke germs. So F's wife consumed the milk and was infected with typhoid and died. Here there is a breach of implied condition and A was liable to pay damages. Are we clear with this? So this is implied condition as to wholesomeness. We have done with all the implied condition. We are left with only one implied condition, that is implied condition as to quality or fitness, which is like a major mountain. That's why I have given that condition in the last. So we are doing a topic of implied condition. Implied condition may we have already done 6 type of implied condition. Now we are left with the last type of implied condition, which is like a major mountain. It will take some time. Now listen very carefully. Acha, this is the last topic that we have to do. Caveat emptor is same copy paste. Implied warranty is very easy. Now the last mountain that we have to do is this. After that, consider your lesson done. After we are done with this condition as to quality or fitness, this implied condition, after that consider your unit 2 done. Okay. Okay, so now we'll be doing the last condition. You know, book mein na, it is given very lengthy, like itta sara and this much. It's given very lengthy. But notes may very easily in very less numbers, very less content. I have explained you this concept of implied condition as to quality and fitness. Now please understand. Condition as to quality and fitness. Now this is something which buyer should take care ki whether his purpose is fulfilling or not. So here there is a concept of caveat emptor. Now please understand, there is a concept of caveat emptor. You must be hearing this word for the first time. Caveat emptor. Caveat emptor means let the buyer beware. Caveat emptor means let the buyer beware. Sorry. Caveat emptor means let the buyer beware. Let the buyer beware means, let's say if I am purchasing phone, I am purchasing phone. So it's my duty to check whether my purpose is being fulfilled or not. Let's say I need a good quality camera. I need a good quality camera in a phone. So it's my duty to check whether that phone has a good quality camera or not. It's not the seller's duty. How will seller get to know that I need a good quality wala phone? I just asked for phone options. He showed me phone ke options, and how will he know? The point is, if I need a goods of particular quality or it should fit my purpose, I need a good for a particular purpose, then I have to check it. Let the buyer beware. Here, seller is not responsible. So generally we will say there is no implied condition as to fitness or quality, because generally the concept of caveat emptor applies, which means that let the buyer beware. So generally the concept of caveat emptor applies, which means let the buyer beware. So seller is not responsible for the quality of fitness generally. But there is one exception in which seller will be responsible for quality and fitness. That means there will be implied condition of quality and fitness only if these 3 conditions are fulfilled. Number 1, the buyer has made the purpose known to the seller. Number 2, he has relied in the skill and judgment of the seller. And number 3, he is ordinary dealing in those goods. One very good example I will tell you for this. Let's say this is buyer. Okay, let's say this is buyer, and let's say this is car showroom, and this is the seller. Let's say there are a lot of cars, okay, in the showroom. Now buyer went to this car showroom and said that I need a car. I need a car. Now seller showed him a lot of cars, and buyer selected one car and purchased it. Okay, buyer selected one car and purchased it. Later on, he found out that this car will not suit his purpose of traveling in hilly areas. Hilly reason. Let's say this buyer wanted car for traveling in very mountains, hilly areas. He bought this car, but later on he found out that this car is very not suitable, not very stable. This car is not suitable for hilly areas. The question is, can he return the car and claim the money back? The answer is no, because if he wanted car for hilly areas, it's his responsibility to check whether this car will fit his purpose or not. Seller is not responsible here. Seller is not responsible whether this good will fit your purpose or not. You asked for car, we sold car to you. We did not do any fraud. So here's generally seller is not responsible for quality and fitness. So generally there is no implied condition as to quality or fitness. So if buyer purchased this car, it is his duty to check whether it will fit his purpose or not. Caveat emptor, let the buyer beware. Let the buyer beware. So it is his duty to check whether this car will fit his purpose or not. Can he return the car? No. Can he claim the refund? No. Generally, there is no implied condition as to quality or fitness. But there is one exception. Let's take the scenario. Let's take another situation. Buyer went to the seller and specifically gave description to seller. Said that, seller, I want a car for hilly areas. I want a car which I can easily travel in hilly areas, mountains and all. So he told seller specifically. And here seller is regularly dealing in car. Yes, he is regularly dealing in cars. He has a business of purchasing and selling car. And he gave description to seller and he completely relied on seller's judgment. He said, buyer said to seller, I don't know anything about car. I will rely on your judgment. So I want a car for hilly region which can travel on hilly region. You tell me which car will be best. I will rely on your judgment. Now this seller suggested this car. Ki, sir, this car is good for hilly region. You purchase this car. And then buyer purchased this car. Later on, he found out that this car is not suitable for hilly region. Now, can he return the car and claim the money back? The answer is yes. Why? Because now it will come under the exception, and here there will be implied condition of fitness and quality. Here there will be implied condition of fitness and quality. Why? Because here buyer has specifically described about the product to the seller. Secondly, he completely relied on seller's skill and seller's judgment. Third, seller regularly deals in car. So if these three conditions are satisfied, then implied condition of fitness and quality will apply, and in that case you can get the refund. You can break the contract. In that case, if there is a breach of implied condition, then you can return the goods, you can cancel the contract, and you can claim your refund back. So guys, generally you have to check whether the quality is okay or not, whether the fitness is okay or not. Seller will not tell you this is low quality, this is high quality. Generally it is the responsibility of buyer. So generally there is no implied condition as to fitness or quality, but only if these three conditions are fulfilled, then only there will be implied condition as to fitness or quality. What are the three conditions? The buyer have give complete description to the seller. Number two, he relied on seller's judgment. And number three, seller regularly deals in that property. So what I'm trying to tell you is, generally there is no condition as to quality of fitness. Are you understanding? Let's say I am buying bottle. So it's my responsibility to check which is the good quality bottle which will suit my purpose. It's not seller's responsibility. So generally there is no condition as to quality of fitness. It is a responsibility of buyer. Caveat emptor applies here. But there will be implied condition of fitness to quality only if these three conditions are satisfied. Number one, the buyer has made known the purpose to the seller. Buyer specifically told to the seller ki I want this car for hilly region. Okay, buyer has specifically told the purpose to the seller, and he relied on skill and judgment of the seller. And lastly, seller is ordinarily dealing in those goods. This is all about fitness and quality. Acha, but one exception is given here. But if the goods can be used for one purpose only, then buyer need not tell the purpose. If let's say that goods can be used for one purpose only, for example, bottle ka one purpose only, holding liquid, so you don't need to specifically tell the purpose. If goods ka only one purpose, one use is there, then you don't need to tell the purpose. Are we clear with this? then there is an implied condition as to fitness and quality. In that case, if let's say now this car doesn't suit your touring purpose or hilly reason, then you can return the car and you can claim your money back. Okay, so what is the point? Generally there is no implied condition as to quality of fitness, but there is this exception. There will be implied condition of quality of fitness only if these three conditions are satisfied. Okay, and lastly, but implied condition will not apply if it is sold under a trademark or patent name. Let's say I went to a shop and I said, give me Amul ghee. I went to a shop, I said, give me Amul ghee. What is Amul? Amul is the brand name, trademark or brand name or patent name, you can say. Trademark or brand name. What I said? I went to the shop and I said, give me Amul ghee. Now, here, he will simply give me Amul ghee. Will he be responsible for the quality? Shopkeeper will be responsible for the quality. What if the Amul ghee is not of good quality? Shopkeeper will be responsible? No, there is no implied condition of quality and fitness here. Why? Because I only said ki give me Amul ghee. So what shopkeeper will do? I asked for Amul ghee, so he will give me Amul ghee. Now if Amul ghee is of not good quality, what shopkeeper can do? Can I return the ghee and claim my money back? The answer is no. Implied condition will not apply if goods are sold under the trademark or the brand name. This is all about implied condition as to quality or fitness. So if you have understood this, come let's read it from the material. Okay, so this is your last implied condition. Come here to the material section number 16 where we will do implied condition as to quality or fitness. So what is given here? Ordinary. Ordinary means generally. Generally there is no implied condition as to quality or fitness of the goods. I told you generally there is no implied condition as to quality or fitness because it is the responsibility of buyer to check the quality, whether quality is good or not, and to check the fitness, whether it will fit his purpose or not. However, the condition as to the reasonable fitness of the particular purpose may be implied if the buyer has made known the purpose and relied upon the skill of the judgment, and seller has been ordinary. Same thing is given here. Key implied condition can be applicable if these three conditions are satisfied. What three condition? Number one, buyer had made known the seller the purpose of his purchase. Buyer has told the purpose of his purchase. Next, he relied on the skill and judgment of the seller. And thirdly, that seller is ordinarily dealing with those goods. Same thing I have written in notes. Okay, and this implied condition will not apply if the goods has been sold under the trademark name. I told you implied condition will not apply if goods are sold under trademark name. Thus, there is an implied condition of the part of the seller that the goods supplied shall be reasonably fit for the purpose for which the buyer want provided. Now, same thing is given here again and again. You know what? You need not underline these paragraph. I think this paragraph and next paragraph is same thing is given again. Ki implied condition will be applied only if following condition are satisfied. Number one, buyer should have made known to the seller purpose for which the good is required. For example, car mein he told to the seller ki I want car for hilly reason. Next, buyer relied on skill and judgment of the seller. And third, goods must be of description that is dealt by the seller, which means seller should ordinarily, I'm writing it in an easy language, ordinarily deal with those goods. Matlab, seller is ordinarily dealing with that good, meaning seller is expert in those goods. Seller is a regular dealer of car. Okay, seller must deal with that goods. Now, in some cases, purpose may be ascertained from the conduct of the parties or from the nature of the goods. Where the goods can be used only for one purpose, then purpose need not be mentioned. Here one point is given ki if the goods can be used only for one purpose, for example, bottle can be used only for holding liquid, so no need to mention the purpose. Okay. And sometimes purpose can be ascertained from the conduct of the parties or from the nature of the goods. In that case, implied condition will be applicable. Are we clear with this? But implied condition will not apply if the goods are sold under the trademark name. Now, this you can cut because it is repeated. Okay. Now come here. Some example is given here. A bought a set of false teeth from B. Now, false teeth, remember that false teeth which you can put it in your teeth and it's look like original teeth only. You don't have teeth, false, fake teeth. My granny wears it, fake teeth. So, A bought a set of false teeth from B, a dentist. But the set was not fit for A's mouth. A rejected the set and claimed for refund. It was held that A was entitled to do so as the only purpose of the for which he wanted the set of teeth was not fulfilled. Guys, please understand what is the use of false teeth? False teeth, of course, to use it in your mouth in place of your original teeth. So don't you think false teeth ka only one purpose is there? Now what happened? A dentist sold a teeth to me. Now that teeth doesn't fit my mouth. So don't you think it is not fitting my mouth? So is there implied condition as to fitness and quality? The answer is yes. Why? Because here I relied on the skill and judgment of the dentist. Dentist is ordinarily dealing with the teeth, and since teeth can be used only for one purpose, so need not mention the purpose. So here there will be implied condition as to fitness and quality, and since that teeth does not fit my mouth, so I can return that teeth to the doctor and I can claim my refund. This is implied condition as to quality or fitness. Okay, one more example is given. Example: A went to B shop. A went to B shop and asked for a Merit swimming wing. Guys, Merit is a brand name. Merit is a brand name. Remember, I told you, if you're purchasing by trademark or brand name, then implied condition will not apply. So I went to the shop. I said I want Marriott key sewing machine. So B gave A the same, and A paid the price. Later, A relied on the trademark of the machine rather than the skill and judgment of the seller. A here, he heard about this brand, that this brand is good, so he relied on the brand ki goodwill, and that's why purchased Marriott ki sewing machine. He did not rely on the skill and judgment of the sellers. So in this case there is no implied condition as to fitness and quality. If that sewing machine is not of good quality, he cannot return and he cannot claim the refund. Why? Because here there is no implied condition as to quality, because here buyer relied on the trademark or brand name. He did not rely on the seller ka skills and judgment. With this, we are done with this topic. Last point: as a general rule, it is the duty of the buyer to examine the goods thoroughly before buying in order to satisfy himself that goods are suitable for his purpose. This is known as caveat emptor, or which means let the buyer beware. So here caveat emptor ka chota sa concept is given. It means that if you're buying any goods, it is your responsibility to check whether it fits your purpose or not. It is your responsibility to check proper it is of good quality or it fits your purpose or not. This concept is known as caveat emptor. That means let the buyer beware. Okay, so if you have done this topic, then similar topic caveat emptor is given, which is just opposite of this. Same to same topic, no need to do it again. Implied warranty, we will do it, but first come to the topic of caveat emptor. Guys, caveat emptor is ditto same to same. You can just have a read over it. Same as implied conditions. I'm telling you, this topic caveat emptor is same as implied condition. I will explain you from the notes. You can just have a read over it. This topic caveat emptor. Caveat emptor. We will understand this in very detail. Now, please understand what do you mean by caveat emptor. Caveat emptor means let the buyer beware. Let the buyer beware means if I am buying, it is not the responsibility of seller to tell me everything. It is my responsibility to check whether goods are of good quality or not, it will fit my purpose or not. So that is known as caveat emptor. Let the buyer beware. Okay, so seller is not bound to disclose the defect in the goods. For example, if I'm selling this let's say mouse, I am selling this mouse. Okay, seller is selling this mouse to me. Now this mouse is not defective. Let's say one button is not working. If you will click now, you will see that one button is not working. So it is not the responsibility of seller to tell you everything that this is the defect if it is clearly visible. It is my responsibility to check whether mouse is properly working or not before buying it. Are you understanding? So seller is not bound to disclose the defect. It is buyer's responsibility. You are buying now. You are putting your money. You are spending your money. You check whether this goods is proper or not for your purpose or not. So it is the duty of the buyer to satisfy himself that goods fit his purpose. Are you understanding? And there is no implied condition as to quality or fitness. This topic is same as quality and fitness that we did. So this caveat emptor ka topic is nothing new. Caveat emptor ka topic is same as the topic that we did in condition as to quality and fitness. Same, copy paste, same topic. If you'll read it, you will understand. Are you understanding? So caveat emptor means it is a duty of the buyer to satisfy that goods are proper and it fit his purpose. Seller is not bound to disclose any defect in the goods. Okay, now these are caveat emptor. Let the buyer beware. But there are certain exception of doctrine of caveat emptor given. So if you'll see caveat emptor, this whole thing I have written here, this 4 lines, if you study, that is more than enough. If question will come, what is caveat emptor? Instead of writing this much now, you can read this 4 sentence, and what is caveat emptor mein, you can write this 4 points also. Now if you will come here, Some exceptions of caveat emptor are given. Exception. Now, you don't need to read all this again. You don't need to read all this again. Why? I'm telling you. Just read the pointers. Just read the pointers. What are the exceptions of caveat emptor? Fitness or quality. Don't you think same point we have done in implied condition? Yes. Exception or caveat emptor are nothing but the implied conditions that we did. Goods purchased under patent or brand name. Goods sold by description. Same we did implied condition. Goods not of merchantable quality. Same we did implied condition. Goods sold by sample. Same. Goods sold by sample as well as description. So you know what? This is nothing new. What I'm trying to tell you, all the 7 implied condition that we did now, they are the exception to caveat emptor. All this 7 condition that we did, all this 7 implied condition that we did, this sale by description, sale by sample and description, merchantable, wholesome, fitness and quality, all these are nothing but the exception of caveat emptor. So if you'll see, exception of caveat emptor is same like implied condition, so it is nothing new. You don't need to do it again. Whatever we studied in that implied condition, that you can write here also in the exception of caveat emptor. Are we clear with this? Only 2 new point is there. Trade usage is a new point there, and seller actively conceals the defect of fraud. This is the new point. Otherwise, this is same. 6th point is same. 5th point is same. 4th point is same. Merchantable quality is same. 5, 6 is same. Sold by description, 3rd point is also same. Patent and brand name is also covered here. Okay. And fitness and quality, same. We have already done. Abhi last topic we did condition as to fitness and quality we did, so this is also same. So if you will see this is nothing new. It's completely repeated. Only last 2 points are new. I'll just explain you in short. So caveat emptor means it is the duty of buyer to check whether goods are of good quality or not, and it fits his purpose or not. Otherwise, seller is not responsible to tell whether it will fit his purpose or not, or seller is not responsible to disclose any defect. So generally it is a responsibility of buyer, but there are certain exceptions where seller can be made responsible. Number one, fitness as to quality of use, that exception that we did. If buyer will specifically tell the description to the seller, rely on his skill, and he is ordinarily dealing with that goods, then we can rely. Next, good purchase under brand name. If we purchase goods under brand name, then brand can be made responsible. For example, I purchase Apple ka phone. Now this phone is defective, so seller will not be responsible, but I can claim compensation from the Apple. Brand can be made responsible. Okay. Next, goods sold by description. Same, if goods are sold by description, then it should be according to the description. Otherwise, seller can be made responsible. Sale by sample, if it should be as per the sample. Otherwise, seller can be made responsible. Sale by sample and description, it should be as per both sample and description. Otherwise, seller can be made responsible. Guys, this point are same we did in implied condition. That same to same points you can write here. Merchantable quality, same we did there also. Lastly, seller actively conceals. Here one point is given ki if seller actively concealed the defect which is not visible by ordinary examination, then also seller will be liable. For example, shoe may he painted it in such a way that it is not visible that it is plastic, that it is paper ka shoe. In that case, seller will be responsible because he actively concealed the defect. Okay. And lastly, trade uses. If trade uses, example, clothes. Trade uses ka example is clothes. Let's say clothes may, it is sometimes it happens that even if we will examine the clothes, sometimes it happens ki it is one size bigger or one size lower. Let's say I purchased M size, but it is a bit loose, it is a bit tight. So for example, trade uses means as per custom. So clothes may, there is custom that sometimes if clothes are not of good quality or if it doesn't look good on me, then there should be some option of return and refund, right? So if it is trade uses, then in that case seller can be made responsible. So guys, caveat emptor ka exception is nothing but implied condition. So if you do implied condition, it's a buy one get one, that you can write here in the exception of doctrine of caveat emptor also. Are we clear with this? With this we are done with this topic. The last topic that we have to do in this lesson is implied warranty. Implied warranty means in these cases there will be implied warranty, and if there is a breach of these 4 implied warranty, then you cannot cancel the contract, but you can claim damages. In case there is a breach of these 4 warranty, then we can claim damages. Number 1, we have already done warranty as to undisturbed possession. That's stolen wala. If I have purchased goods, I have warranty of undisturbed possession. If let's say someone else, if that goods is stolen and the true owner takes the possession of that goods from me, then I can claim compensation from the seller. Okay, so implied warranty, please come here to the implied warranty wala topic. Implied warranty wala topic, what is given here? Implied warranty means which the law implies into the contract of sale, which is not given in the contract but it is implied by law. In other words, it is a stipulation which has not been included in the contract by express word. Implied means it is not expressly given in the contract but it is assumed, it is implied, but the law presumes that same thing is given. Okay, now these may be excluded by the course of dealing between the parties. Here one point is given ki if you don't want to follow implied warranty, then expressly you can exclude it in your contract. In your contract you can write ki implied warranty will not be applicable. There are four types of implied warranty. First one we have already done, warranty as to undisturbed possession. Undisturbed possession means right to enjoy those goods, no one can take those goods from us. So let's say if that goods are stolen and the rightful owner takes that good from us, then we can claim compensation from the seller. That same example Amitabh Bachchan wala, remember, example apply here. An implied warranty that buyer shall enjoy the quiet possession of the goods. That is to say, if buyer having got possession of the goods later is disturbed of his possession, then he can claim damages from the seller. If someone takes the possession of that goods from him, then he can claim compensation from the seller. For example, X buys laptop from Y. X buys laptop from Y. After purchase, X spent some money on its repair. X, after purchasing, he did some repair also. Unknown to parties, it turns out that laptop was stolen and X has to deliver that laptop to the rightful owner. Later on, they found out that that laptop is stolen. Later on they found out that laptop is stolen, that laptop does not belongs to Y. So let's say that laptop belongs to Z, so X has to return that laptop to the rightful owner. In that case, he can claim the refund also from the Y under implied condition, and he can claim damages also. Whatever repairing cost he have paid, that damages also he can recover from Y. Guys, please understand, the same thing is covered in implied warranty also, and the same thing was covered in implied condition also. Remember the first implied condition as to title, only language is different, otherwise that first condition and first warranty is same. Okay, the second warranty is warranty as to non-existence of encumbrance. Encumbrance means security. If I am purchasing any goods, that should be free from any security. That means that should not be mortgaged or pledged. The goods that I'm purchasing should be free from any encumbrance. If there is any encumbrance or any charge on the goods and I incur any loss because of that, then I can claim the damages from the seller. Let's understand this with the help of example. Now please come here. Warranty as to, there is an implied warranty as to non-existence of encumbrance. Here one point is given, there is an implied warranty that goods should be free from the encumbrance. Encumbrance means security, mortgage, pledge, charge, so many words in the favor of any third party. Example, you will get it by example. Let's understand with the help of example. A pledges his car with C for a loan of 15 lakh rupees and promises him to give him the possession the next day. So here one point is given ki A took a loan from C and pledged his car to C. How much loan? 15 lakh ka loan. Now what happens? A then sells the car to B. After that, don't you think us car mein pledge is created? Yes, car mein pledge is created. So that car is encumbered. Now A sold that car to B. Okay, B don't know that this car is encumbered or this car is given as a security to C. Okay, after giving car as a security to C, A sold that car to B. Now what happened? Who purchased it on good faith without knowing the fact? He did not know the fact. Later B may either ask A to clear the loan himself or pay the money and file a suit against A for the recovery of the interest. Here one point is given ki now here, if let's say B, now the car is with B, so if he repays the loan of 15 lakh to the C because he wants to keep the car, otherwise C will sell the car in order to recover the money. So here either B can ask A repay your loan or return your loan, or B can himself clear the loan to C 15 lakh ka, and later on he can claim this 15 lakh ka loss from A by filing a case against A. So here he can claim these damages and loss that he paid to A. If he had to pay 15 lakh to C, this loss that he incurred, he can recover it from the A. This is implied warranty. So if there is a breach of implied warranty, he can claim damages or whatever loss is suffered. Third implied warranty is your warranty as to quality or fitness by usage of trade. Same clothes wala example. So generally, clothes may users and trade only say that. Of course, clothes, sometimes it doesn't fit you. So if you bought any cloth, if it doesn't fit you, you can obviously get it exchanged, or if let's say it is torn from somewhere, you can you can claim damages. Are you understanding? Or you can get it replaced. Let's say I bought XL size, it is a little big for me, so I can get it replaced with the M size. So there is warranty also as to quality or fitness, if and only if it is by usage of trade. So generally there is no such warranty, because generally KV tempter applies. Guys, we have already done quality and fitness ka condition, also condition as to quality and fitness, warranty as to quality and fitness. Both में one point is there. Generally there is no condition as to quality of fitness, and generally there is no warranty as to quality of fitness. Why? Because of KV tempter. KV tempter means it is buyer's responsibility to check whether that goods fit his purpose or not, or it is of good quality or not. So generally KV tempter applies. That is why there is no such warranty as to quality or fitness. Generally there is no implied warranty as to quality of fitness. Generally there is no implied condition as to quality of fitness, and there is no implied warranty as to quality or fitness. But there is one exception only in the usage of trade. Usage of trade means if generally as per the pattern or custom, people do provide warranty, in that case then it will be provided. For example, clothes के case में generally people do provide warranty कि ठीक है मैडम नहीं आया तो replace करवा लेना. So if it doesn't fit you, you can get it replaced. So if only if users of trade says that okay there is a warranty, then only there will be warranty as to quality of fitness. Otherwise generally there will be no warranty as to quality of fitness because of KV tempter. Same point we did in condition also, ki generally there is no condition as to quality of fitness, except for one exception was given. Okay, so now come here to the material. Warranty as to quality of fitness by users of trade. An implied warranty as to quality of fitness for a particular purpose may be annexed or attached by the usage of trade. This word is very important here, usage of trade. Ki you will get implied warranty as to quality of fitness for a particular purpose only if it is with respect to usage of trade. Are we clear with this? Regarding implied condition and warranty as to quality of fitness, the rule of let the buyer beware applied. That is, seller is under no obligation to reveal. Here one point is given कि generally when we talk about the implied condition or implied warranty as to quality of fitness, it doesn't apply. Why? Because generally rule of KV tempter applies, let the buyer beware. Buyer has to take care of the goods. Buyer has to check whether it is of proper quality or not. But here implied warranty as to quality of fitness will apply only in case of uses of trade. And last warranty is your disclosure of dangerous nature of goods. If goods are of dangerous nature, some goods are dangerous nature, so you have to disclose it. This is implied warranty, and if you don't disclose the dangerous nature of goods, then you have to give the compensation. Buyer can claim the damages from you. This is implied warranty. That's why now whenever you purchase any cream, any medicine, उसमें ना direction to use में it is clearly given कि keep it away from eyes and keep it away from, don't eat it, keep it away from children, store it in the cool place. Are you understanding? So I will tell you this का one case. There was a powder. That powder में ना spring was there. There was a powder, there was a spring कि when you open that powder ना suddenly that all the powder it comes like what, I'm not getting the word. There was a powder ka box. When you open that powder ka box, suddenly all that powders come to your face. So you have to open it very carefully because it suddenly comes all out. So it is dangerous. So you have to clearly mention it कि don't open it suddenly, keep it open it from side, so that otherwise it will come to your eyes. So if any goods is of dangerous nature, you have to disclose it. Otherwise if anyone suffers any loss, then you have to compensate the damages. For example, there was a powder, a seller sold a powder which was dangerous. Usse na, as soon as you open it, it suddenly comes all in your face, but it was not written anywhere, it was not disclosed ki open it carefully. And there was one lady, she bought the powder, she opened the powder, and suddenly all the powder came to her eyes, and she became blind, and some eye problem and all. So here, can she claim damages from the seller? Yes, she can claim damages. This is implied warranty as to dangerous nature of the goods. Now quickly come here, last implied warranty, disclosure of the dangerous nature of the good. Here one point is given ki where goods are dangerous in nature. If the goods are dangerous in nature and buyer is ignorant of the danger. So if goods are many goods goods may certain danger is there, so you have to mention it, especially electronic products may please turn the switch off after use. Gas may, electronic products like microwave, induction and all kitchen ke products may, if they are dangerous nature, then seller have to warn the buyer. Okay, and buyer is ignorant about the danger, then seller must warn the buyer about the danger. If there is a breach of warranty, then seller is liable to pay the damages. If seller will not warn the buyer about the damage, about the danger, then if buyer will suffer any loss, then he has to pay the damages or the compensation seller. This is implied warranty as to dangerous nature of goods. And with this we are done with this particular lesson, guys. This last topic, exception of caveat emptor, this you don't need to do again. This you can study from the implied condition also, which we have already done. With this we have done with unit number 2. Guys, I'm saying it again, in case of any doubt, please feel free to ping me over Telegram, and I will keep on uploading the remaining unit 3 and unit 4 also in the same unlisted playlist. I'll be sending this unlisted playlist link in the WhatsApp group. Please be patient. First watch these two units, unit 1, unit 2, and before watching unit 3, unit 4, you have to again do the self study of unit 1, unit 2, learn unit 1, unit 2, then only go for watching unit 3. Otherwise it will all become khichdi and pongal in your head. Are you understanding? It will all mix in your head. You will get confused because you are learning something new. So make sure that before starting next unit, you do the self study of unit 3, unit 1, unit 2 completely. You understand this topic, you learn this topic, then only unit 3 will be clear to you, because unit 3 is a bit technical, a little bit technical. So make sure that you study this properly and then only you go through it. Okay, so before watching unit 3, give 1 or 2 days, give few days to revise this lessons, unit 1, unit 2, learning this and doing the questions of unit 1 and unit 2. Solve the all the questions given in the last page of the unit 1 and unit 2. Unit 1 and unit 2 ke last page mein some questions are given. I think 13 MCQs are there, and 7 descriptive questions are there. Solve all the MCQs and descriptive question and then only move forward. Guys, I'll keep on uploading the remaining videos in the unlisted playlist. Keep on checking the unlisted playlist. Uska link I'll be sending in the group. Okay, so now for any doubt, please feel free to connect directly with me over Telegram. If you have any question of law, you need any other recording, you need any other revision video of Contract Act, Partnership Act, or let's say Sales of Goods Act, you need any revision video, you need any other video or any other help from my side, please contact me directly over Telegram. You can ping me over Telegram at the rate CS Ishika AGRAWAL at the rate CS Ishika Agrawal. Okay, with this we are done with your unit number 2. It was a small and sweet lesson. It can be done easily. Unit 3 is a little technical, so I would say you first complete the self study and then go for unit 3. Okay, I'll be uploading unit 3, unit 4 also, Negotiable Instrument Act also, and the agency also. Meanwhile, please keep on studying the other topics until I upload the remaining topics. Please revise Contract Act. Contract Act ke short notes are provided to you by a drive link already sent in the WhatsApp group. Check the WhatsApp group for the drive link of all the notes. Please complete Contract Act ki self study along with the notes. Short notes are given, so go through the short notes and complete the self study of Contract Act. Okay, that's it for now. See you in the next video. Keep learning, keep growing. All the very best. Okay, all the good wishes to you. Keep preparing well. See you in the next video. Take care. Bye bye.